I'm not feeling well, Your Lordship.
Not feeling well.
Not today, only Lord.
You are for the petitioner?
Appeal. 8 and 16, Your Lord.
Very well. We are just marking it. Formal order will be passed.
Eight, I am appearing for the private respondent debt petitioner.
All right.
I got some difficulty for 2 days, my lord. It's maybe fixed on Monday.
Not this week in that case.
My lord.
Right, record an order, item number 8. By consent of the parties, list the matter on 9th.
Obliged.
Record your appearance also.
Good.
And in 16, who is your other side?
We have for the other side.
Not this week or
Not today, Your Lordship. No, no.
not today?
No, Your Lordship.
On the prayer made by the learned advocate representing the petitioner? List the matter tomorrow.
Lordship.
8 and 16.
Item number 1, SAT 3 of 123.
Actually, I am for that. Just to book the single thing. It is already been granted.
Admitted.
Already admitted.
All right.
And my paper book is also ready. You also will get called on Monday.
Please come. The second appeal has been admitted by the court on 10th October 2023. Stuff. Let the lower court records be forwarded for preparation of the paper books.
I have already prepared the paper book.
Without the lower court records, whatever papers you have, on the basis of that you have prepared.
Yes, I have prepared.
I don't know.
They are very fast.
A formal order is to be passed, isn't it? Then, whoa. List before the honorable single judge.
Item number 2, WPCT 48 of 124.
I pay for the respondent authorities.
For the appeal. Your Lordship.
Yes.
Here, Your Lordship, the income, he was terminated from service on the ground of production of false certificates. This is the
Which certificate was false?
community certificate, OBC certificate.
All right.
That is the ground of termination. His probation period was completed. After the completion of the probation period, he has been terminated without conducting any inquiry. My point, law point is that, Your Lordship, as per the decision, Your Lordship knows, Parshottam Lal Bhigra, and thereafter number of decisions are there, that there is no distinction between a probationer, contractual, ad hoc, permanent government servant, so far as Article 311 is concerned. Opportunity, a proper inquiry and opportunity of hearing has to be given to the incumbent. That has not been given. Now, the point was, Your Lordship, before the learned tribunal, I agitated the point relating to stigma. Because when an incumbent is terminated on the ground of production of false certificate, it's creating a stigma. There is no doubt about it, Your Lordship. If somebody is, his work is unsatisfactory, or there are certain technicalities which have not been fulfilled before confirmation, I can understand. But here the termination was done in the termination order itself. It is mentioned that on the ground of production of false certificate, he has been terminated. Now, point of law is that, Your Lordship, whether an incumbent can be terminated without conducting any inquiry as per Article 311 or creating a stigma, can it be done? This is the point. Now, Your Lordship, I can show the papers and documents, Your Lordship, are all annexed with the application. Because I'm praying for an entering order. The reason is that the incumbent is still working in the department.
After termination?
Yes. What happened, Your Lordship? He approached the Honorable High Court at Madras because he was posted at Chennai at that relevant point of time. So he filed a writ application before the Honorable High Court at Madras, and the Honorable High Court has granted an interim order of stay of the order. That stay continued for around 14-15 years.
At which stage?
In the initial stage when he was terminated. That is,
Alright.
sometimes in 2003 he was terminated. And stay was granted in 2003. He continued with the service. And sometimes in 2018, that writ application the Honorable High Court said it is not maintainable here, you have to go and file in the appropriate court. Then your lordship withdraw it and filed it before the tribunal. In 2018, it was filed immediately. It was heard into 2024 and it has been dismissed. Even now he is working. I am praying for an interim order, otherwise your lordship matter also can be heard finally. All papers
Okay.
are there.
Show me the rejoinder of the authority before the
Yes.
tribunal.
Yes, yes. They have filed it, it is at page number.
$77.
They are accepting the point that it is not a termination simplicity. They
It
have
is.
also stated that it is on the basis of, on the ground of production of false certificate.
Where is your caste certificate?
Yes, your lordship. It is page number 44. 40. Why inquiry is necessary, that also I will establish. That there is a merit to conduct an inquiry. It is not that simple, that this particular certificate is considered as a false certificate. Actually,
In the reply, what is their contention? How did they get to know that this is a false
they have
certificate?
referred the matter to the collector, from
Yes.
where the certificate has been issued. Collector has said that this particular certificate does not say that it is a OBC. It is not there in the central list. That's it.
Page number
Certificate
89.
is- That has not been stated by the collector. Page number 89 may be seen.
89 is the,
Hindu Reddy Ganjam. This caste is not a listed caste in the central list. That is what has been stated by the
Is
collector.
it there in the list of the islands or something?
Yes, Tamil Nadu list it is there.
It
I
is
have
there.
got it, yes. Not only that, I have got the judgment of the Honorable.
But then will the Tamil Nadu list be followed in the islands?
no.
This is central list. Central list, it should be there. The
No,
problem
but the
is
central list will not be followed everywhere.
central list will be followed everywhere, Your Lordship. I'm not saying that. My point is that there I have got.
They are not in central list.
No, just
Not also in the central.
Not in
list.
the central
in
list.
Tamil Nadu list, it is there. This is central government post.
State.
It is
Central
not a islander post. It is
All
central
right,
government.
central government post.
Yes. Tamil Nadu list, it is there. Not only that, Your Lordship, that's what I am submitting. Your Lordship may kindly see. Your
District of Tamil Nadu.
Lordship may kindly see this. Kindly see this, Your Lordship. Your Lordship will get the answer why inquiry is necessary. In a case, Your Lordship, a person approached the Madras High Court saying that this particular caste, Hindu Reddy Ganjam, that caste is not a OBC caste and therefore he should get the EWS quota. The Advocate General has submitted before the Honorable High Court that it is under the central list. And therefore that particular person has not been granted EWS reservation. Now, these are the things which has to be looked into at the time of inquiry. And you see this clearly say Advocate General is submitting this particular
Yes.
caste in the central list.
Additional advocacy following seven. Resolution may be considered. Are you aware of this order?
No, my lord, this is first time they are submitting, not before the tribunal.
Which list did the authority rely upon?
My lord,
I'll come to you. I'll finish with Mrs. Nag and then.
Here, my point is that, Your Lordship, there are materials for the purpose of conducting an inquiry. Now, Your Lordship, I have judgments in line with me, Your Lordship, that even for a probationer or ad hoc or contractual, if there is any allegation and a person is terminated, because they have terminated me on the ground of false certificate, then as per Article 311, inquiry is pending. Judgments are there, Your Lordship.
No, please do not show those judgments.
Yes.
Show the order of termination.
Yes, Your Lordship. Order of termination is page number 48. May I place, Your Lordship?
Yes.
In accordance with the terms and conditions of offer of appointment issued within this office memorandum number this, dated this, and after having established that the caste claimed by him as OBC is found false, the service of Shri Selva Kumar, this, who has been appointed provisionally to the post of watchman and ad hoc basis, pending verification of caste certificate of OBC, with the office order number this, dated this, has been terminated with immediate effect.
Mentions that the caste claimed by him as OBC is false,
False.
not that the certificate is false.
Your Lordship, just a minute. Further,
Caste. Which is the list that the respondent authority is relying upon where
no list
this,
has been produced. They have not produced any lists. They have relied upon only the collector's letter.
where is that letter?
Letter is at page number 89.
This mentions that the Hindu Reddy Ganjam is not included in the central government list. Show
Yes.
the central government list.
That is not NHG, Your Lordship, because I don't have. I don't have the central government list. They have also not relied upon central government list in the before the tribunal also.
Because that is the only thing that is to be seen.
That is to be seen, Your Lordship.
Where is the list? Where is the list?
it is not there, my lord. It was not called for earlier.
But if this is the communication relying upon which service of an employee is taken away, then the list should have been there before the court, isn't it?
Yeah.
They have stated that the individual do not belong to OBC community.
Download the list from the site of the
Yes.
list is the.
My lord, as I corrected, I will come back.
Please
Central list.
bring the list.
Yes.
Which is the list you relied upon?
No,
They have not
They-
relied, while terminating my service,
Yes.
they have not relied upon any list.
This collector has given this letter relying upon a list. Where is that list?
collector has stated that verifying his caste certificate.
Not the caste certificate, it mentions that the community is not included in the central government list.
Yes. The individual do not belong to OBC community. They have cited.
So
Yeah.
where is that list?
As per the central government list, where is the list? Central government list.
Please come.
I will come back with the list of the central government.
This is the only part.
Only point that is to be seen. The order dated 22nd November 2024, passed by the Central Administrative Tribunal. Upholding the termination of the service of the petitioner is impugned in the instant writ petition. Stop paragraph. The service of the petitioner stood terminated, relying upon a communication made by the collector, mentioning that the community within quotes Hindu Reddy Ganjam is not included in the central government list of OBC. The petitioner do not belong to the OBC community. Stop paragraph. The appointment of the petitioner was under the reserved caste. Stop. The list relying upon which the collector issued such communication is required to be looked into by the court. Stop paragraph. Learned advocate for the respondent authority is directed to produce the central government list of the OBC candidates. When do you come back?
A week's time may be given.
1 week for the list, which is very readily available everywhere.
Next
Anyway, 11th.
11.
The paragraph, it has been submitted by the learned senior counsel representing the petitioner that her client is still in service. Stop. The service of the petitioner shall not be disturbed till 16th December 2024 or until further order, whichever is earlier.
Obliged.
Highly obliged, my lord.
You check up the order of the Madurai bench.
But I already
My lord.
sent you a note.
I shall.
Yes. It's a- He's saying it's,
Item number 3,
Yes, sir.
W6014 of 2024.
My lord, this is a writ petition, my lord, challenging the order passed by the Central Administrative Tribunal. My lord, the matter concerns certain financial benefits, my lord, to the employee in question. My lord, in my humble submission, the facts have not been at all appreciated, my lord, by the CAT. My lords, I'll take your lordships through the documents first before coming to the, with your lordship's permission. My lord, may first have page 99. This is the initial, my lord, order whereby certain financial benefits were given to the applicant, original applicant before the CAT. In pursuance of Government of India, Ministry of Finance, such and such dated 1st June 2001, extending revision of pay scale to draftsmen under all central government offices. The existing pay scale in respect of Shri T.K. Roy, draftsman, is hereby revised from 4,000 to 6,000, 4,000, 6,000 to 5,000 to say 8,000 with effect from 30th October 2001. So my lord will notice, my lord, that this is relying upon a Ministry of Finance circular dated 1st June 2001. My lord will also, your lordships will also notice that the pay scale at which he was working was 4,000 to 6,000, and what the pay scale that is to which he is upgraded is 5,000 to 8,000. And my lords will also notice that this benefit is being given with effect from 30th October 2000. Now, my lord may have the document at page 100. This, my lord, is a letter dated 18 July 2006. Now, there is no dispute about the fact that this benefit was initially given in 2001 and then this letter came in 2006. Now, my lord will see, this is the letter addressed by the personnel department of the Andaman and Nicobar administration to the principal of Dr. B.R. Ambedkar Government Polytechnic, which is the employer. Now, my lord may see the contents of this letter. Subject is extension of financial upgradation to draftsmen on completion of 8 years service. It is brought to the notice of this administration that the pay scale of Shri T.K. Roy, draftsman of your department, has been revised from rupees 4,000, the slab is 4,000 to 6,000, to rupees 5,000 to 8,000, vide your office order dated 27th August 2001, which I just read out, on completion of 8 years service in the grade in terms of Government of India Ministry of Finance OM dated 1st June 2001. In fact, different period of services prescribed in the OM dated 1st June, I'll come to the OM subsequently, is exclusively for determining the eligibility for placing in the applicable revised pay scale recommended by 5th Central Pay Commission to those draftsmen in different departments other than CPWD who do not possess the prescribed qualification, and excluding those who have already derived the benefit envisaged in the OM dated 19th October 1994, issued by Government of India Ministry of Finance, i.e. the revised scale of pay allowed to draftsmen grade 1, 2 and 3 in all Government of India offices irrespective of qualification, as has been extended to draftsmen grade 1, 2 and 3 working in CPWD on the basis of award of Board of Arbitration. The order of the ministry dated 1st June 2001 is to be read along with the orders dated 13th March 1984 and 19th October 1994. Since the draftsmen of your department already placed in the appropriate pay scale prior to implementation of 5th Central Pay Commission's recommendation as envisaged in Government of India MOF dated 19th October 1994, and the revised pay scale applicable to his post is 4,000 to 6,000, the question of again revising the pay scale of said post from 4,000 to 6,000 to 5,000 to 8,000, taking into consideration of different period of service as envisaged in the order of the ministry dated 1st June 2001 does not arise. Once the draftsmen are placed in regular pay scale, further promotion would be made against available vacancies in higher grade and in accordance with the normal eligibility criteria laid down in recruitment rules. Ministry has also clarified at para 6 of 1st June 2001 that draftsmen who have already been covered by the orders contained in the OM dated March 13, 1984 and October 19, 1994 shall be eligible to be placed only in the applicable revised scale of pay already approved for the common category of draftsmen in pursuance of recommendation of 5th Central Pay Commission. Therefore, action of the department to revise the pay scale of draftsmen from 4,000 to 6,000 to 5,000 to 8,000 on completion of minimum 8 years service is found to be incorrect. It appears the department has made deliberate attempt to extend undue financial benefit to the incumbent, distorting the contents of administration's letter and also of MOF's OM referred to above, which is otherwise inadmissible. By doing this, department has committed gross financial irregularity, which is to be rectified at the earliest. However, draftsman of your department who is already in appropriate pay scale of pay of 4,000 to 6,000 is eligible for awarding revised scale of pay of 5,000 to 8,000 as first financial upgradation under ACP scheme in terms of DOPT office memorandum such and such only on completion of 12 years regular service in that grade. Since this department is receiving proposals from different departments for revision of pay scale of draftsmen at par with their counterparts working in the Directorate of Shipping Services and Government Polytechnic, which are turned down finding no merit, you are requested to initiate necessary action to rectify the irregularities in extending the revised pay scale to draftsmen of your department as stated above, and a compliance report to this effect may be furnished to this department at the earliest but not later than 21st August 2006. So, my lord, after this letter, the first revision, my lord will find at page 102. In partial modification of this office order, number 626 dated 27th August 2000, and in pursuance of Government of India Ministry of Personnel Public Grievance and Pension, Department of Person and Training, and on the recommendation of the screening committee, Principal Dr. B.R. Ambedkar Government Polytechnic, Pahargaon, Port Blair, has been pleased to extend the benefit of first financial upgradation under ACP scheme to Shri T.K. Roy, draftsman in the scale of pay mentioned against his name, who has completed 12 years of service or more without any promotional avenue with effect. So therefore, upon his completion 12 years of service in 2008, this financial benefit is being conferred. So my lord, the financial benefit is scale of pay of 5,000 to 8,000. Now what happens after this is, my lord, there is a second revision. Now admittedly this matter could have been handled better, but my lord, be that as it may, my lord, the facts are like this. My lord may now have page 108. Page 108, my lord, is an office order dated 5th December 2014. In terms of Government of India DOPT OM number dated such and such, read with Government of India DOPT OM such and such, read with Government of India such and such, and on recommendation of screening committee, Principal Dr. B.R. Ambedkar Institute of Technology, Port Blair, has been pleased to grant financial upgradation under Assured Career Progression Scheme, modified Assured Career Progression Scheme to the following Group C employees. Now kindly see serial number 5. Now this is very important, my lord. Kindly see the existing grade pay is that is the fifth column. PB2 plus GP rupees 4,200. The upgraded grade pay is 4,500 to 7,000. Now kindly see the remarks, which is the last column. The incumbent was earlier awarded first ACP in the scale pay of 5,000 to 8,000 instead of scale of pay of 4,500 to 7,000 with effect from 30th October 2004. Video order dated 14 January 2008 is hereby superseded. Now, my lord, what has happened is, initially, he was given promotion. When he was given promotion, the personnel department wrote and said that you couldn't have done this because that the 1st June 2001 is not applicable, but you have to give him, you can give him ACP. But while giving ACP, they committed another mistake. They gave him ACP in the scale of 5,000 to 8,000, whereas the next scale was 4,500 to 7,000. So this was thought to be corrected, my lord, at page 108. Now against this, my lord, at 110, the applicant makes a review application. The review application, I may see the page 110. T.K. Roy, draftsman, is writing a letter with respectfully, I am to submit that I was awarded first ACP in the scale of pay of 5,000 to 8,000. Vide order number 31 dated 14 January 2008 and later on it was superseded. Vide order number such and such dated 55th of December 2014 in the pay scale of 4,500 to 7,000 without assigning any reason thereof, which may cause financial loss with effect from 30th October 2004. In this regard, requested to review. So here is the relief that he is seeking is also limited to only the second modification. He is not seeking any reliefs where the first issue, that is not giving him the promotional avenue, not applying 1st June 2001. He is only saying that after you decided that 1st June 2001 is not applicable and you decided to give me ACP of 5,000 to 8,000, your act of then further reducing it to 4,500 to 7,000 should not have been done. This is his contention. Now kindly see after this detailed consideration, my lord. This is a slightly, my lord, I also took some time to understand. My lord may kindly have page 111 onwards. This is very important because, my lord, this explains the controversy which the cat has not looked at. Kindly see, this is the file noting of the employer. Video representation dated 11th December 2014. Shri T.K. Roy, draftsman, has sought the following reliefs. That I was awarded first ACP in the scale of pay of 5,000 to 8,000. Video order dated 14 January 2008 and later on it was superseded. Video order dated 5th December 2014 in the scale of pay of 4,500 to 7,000 without assigning any reason which may cause huge financial loss. Requested to review the order dated. Again, this review is sought only of the order dated 5th December 2014. In this context, it is submitted that the post of draftsman created with the following two numbers orders. That Shri T.K. Roy, draftsman, was appointed in pre-revised scale of pay of 330 to 560. Revised pay as per 5th Central Pay Commission is 4,100, 6,000. Vide this order dated 29th October 1992 and he reported for duty on 30th October 1992. That on completion of 12 years regular service, Shri T.K. Roy, draftsman, was granted first ACP in the scale of pay of 5,000 to 8,000. Vide order numbers dated 14 January 2008 with effect from 30th October 2004. That on completion of 20 years of regular service, the name of Shri T.K. Roy, draftsman, was placed before DPC for award of second MSCP. On scrutiny over his proposal, DPC has observed that first ACP wrongly granted in the scale of 5,000 to 8,000 instead of scale of pay of 4,500 to 7,000 due to non-availability of promotional channel in the recruitment rule. In the next higher post, which is lab technician, instructor, etc., DPC has proposed to rectify and recommend for second MSCP in grade pay of 4,200 in PB2 with effect from 30th October to 2012 on completion of 20 years of regular service. That based on the recommendation of DPC, first ACP was superseded by awarding the scale of pay of 4,500 to 7,000 with effect from 30th October 2004 and granted second MSCP in the grade pay of 4,200 in PB2 with effect from 30th October 2012. If approved, we may obtain view of personal wing. Now kindly see that page 113. This is very important, my lords. According to me, the notes at such and such for the post of draftsman placed in the file reveal that post of draftsman is an isolated post. As per condition 7 of ACP scheme, in case of isolated post in the absence of defined hierarchical grades, financial upgradation shall be given in immediately next higher standard common pay scales as indicated in Annexure 2 of Part A of the first schedule annexure to the Ministry of Finance, Department of Expenditure Gazette notification dated 30th September 1997. The post of draftsman in Debright is in the pre-revised scale of 4,000 100, 6,000. As such, the incumbent working in the said post as per above said condition shall be entitled for financial upgradation in immediately next higher pay scale of 4,500, 125, 7,000. The post of draftsman in APWD is having hierarchical grades and is not an isolated post. The first and second financial upgradation granted under ACP, MSCP to draftsman such and such is correct. File may be returned to Secretary Education. Now, my lords will see the memorandum at page 116. Memorandum dated first, this is 16th March 2015. Whereas Shri T.K. Roy, draftsman video application has submitted that. Now, my lord, this I have already read. Now, kindly see on the next page, page 117. That on completion of 20 years regular service, the name of Shri T.K. Roy, draftsman, was placed before DPC for award of second MSCP. On scrutiny over his proposal, DPC has observed that first ACP wrongly granted in the scale of 5,000 to 8,000 instead of scale of 4,500 to 7,000 due to non-availability of promotion channel in the recruitment rules in higher post. DPC has proposed to rectify and recommended for second MSCP in the grade pay of 4,200. Then my lord will see that based on the recommendation of DPC, first ACP was award superseded by awarding scale of pay of 4,500 to 7,000 and granted second MSCP in grade pay of such and such. Whereas the case was referred to personnel wing to confirm correctness of order dated 5th December 2014 and accordingly personnel wing has observed that first and second financial upgradation granted under ACP MSCP scheme to Shri T.K. Roy, draftsman is correct. Now therefore application of T.K. Roy, draftsman dated 11 December 2014 is disposed of with no action. This has the approval of the competent authority. Now, as a consequence, my lord, at 118, there is a memorandum for recovery. All these documents, my lord, were placed before the CAT. Now, my lords will see one thing. The critical document, my lord, which is to be seen is my lord, the 1st June 2001 office memorandum. Because, my lord, what the CAT has done, CAT has gone 2 steps behind. The CAT says 1st June 2001 should have been granted, whereas his grievance all this while was, very well, you haven't granted me 1st June 2001, that is fine. But what you have done wrongly, according to the original applicant, is the second revision dated 5th December 2014. So he doesn't have a problem with 14 January 2008. Where the employer has said that 1st June 2001 could not have been granted. You cannot be promoted to the higher scale. However, because you are already in the pre-existing scale, however, you will be entitled to ACP. Now that ACP of 5,000 to 8,000 was modified subsequently on 5th December 2014 saying that the ACP scale was 4,500 to 7,000 and not 5,000 to 8,000 because the next higher scale was 4,500 to 7,000. Now, all this while, his grievance is that I should not have ACP of 5,000 to 8,000 should have been given to me. But the CAT actually goes one step behind. The CAT says that the first decision itself was wrong of 14 January 2008. Now, to appreciate the CAT's view, my lord may first have the 1st June 2001 circular, which is at page 97. This is 1st June 2001. In pursuance of an award, this is recommendations of the 5th Central Pay Commission, revision of pay scale of draftsmen and Government of India offices. In pursuance of an award of the Board of Arbitration, draftsmen in grades 1, 2, and 3 in the Central Public Works Department in 3rd CPC pay scales of 425 to 700, 330 to 560, and 260 to 430 respectively were placed in the higher pay scales of 550 to 750, 425 to 700, 330 to 560 respectively. Orders were also issued subsequently in these departments OM dated March such and such 1984, extending these scales of pay to draftsmen in all the Government of India offices notionally from May 13, 1982 and actually from November 1st, 1983, subject to their recruitment qualification being similar to those applicable in the Central Public Works Department. Following further consideration, orders were issued by this department such and such dated 19th October 1994, extending the corresponding 4th CPC pay scales to even those who are not possessing the prescribed qualification, subject to the condition that they had instead rendered the length of service prescribed therein specifically for the purpose. The 5th Central Pay Commission having been appointed in the meantime, the benefits of the higher scale had not flown as envisaged to all personnel in various departments who had not completed the prescribed service if the applicable in the applicable scales of pay. The 5th Central Pay Commission has had further revised the scales of pay of the common category of draftsmen. The staff side had invited attention to the anomalous situation that had arisen as a consequence in the National Anomalies Committee. They had raised the demand that revised pay scales recommended by 5th Central Pay Commission should be extended to the draftsmen in all central government offices, due weightage being given for the service rendered by the personnel not possessing prescribed qualification in different departments, as envisaged in this department's OM dated October 19, 1994. Following the consideration of this demand in consultation with the staff side, the President is now pleased to decide that draftsmen in different departments other than Central Public Works Department who do not possess the prescribed qualification, and very significantly, my lord may note, and excluding those who have already derived the benefits envisaged in the OM dated 19th October 1994 may be placed to the scales of pay recommended by the 5th CPC on completion of minimum service, including service rendered in corresponding pre-revised scales as indicated below. So, my lord, the benefit, my lord, is been given specifically to those who have not already derived the benefit envisaged in the OM dated 19th October 1994. And the specific contention of the administration was this did not apply because he had already got the benefit. He was already in a grade pay scale. Now, kindly see, my lord, the impugned order, which is at, my lord, page 20. My lord, the prayers in the original application are set out at page 21. Of after, kindly see prayer A, order be passed quashing the impugned order dated 5th December 2014 and order dated 14 January 2008. Despite the fact that so far as 14 January 2008 is concerned, he had raised no grievance. In fact, he had acquiesced in that order. Now, my lord will see this facts, my lords, have already placed. There is not much dispute. Kindly see at page 22, para 2.7. This is, of course, recording the contentions of the original applicant. Since the applicant was already in the scale of pay of 5,000 to 8,000, respondent authorities ought to have granted first financial upgradation under ACP scheme in the next scale of pay of 5,500 to 9,000. Instead, the respondent authorities changed the date of his placement in the scale of 5,000 to 8,000 with effect from 30th October 2004 and further ordered recovery of excess payment for the period between 30th October 2000 to 31st January 2000. He deposited the said amount ordered to be recovered after withdrawing the same from his GPF account. So he even acquiesced to this. And he even acquiesced to the fact that the financial benefit was given to him erroneously in 5,800 to 8,000 instead of 4,500 to 7,000. Now, my lord will see after that the contentions of the respondent are recorded. And if my lord then comes to page 25 is the consideration of the CAT. Heard learned counsel for both the parties and examined the material on record. The applicant was placed in the pay scale of 5,000 to 8,000 in pursuance of Government of India Ministry OM dated 1st June 2000, which is reproduced below. My lord, this I had already read. Kindly see page 26 now, para 6. The applicant had not availed any benefit under OM of Department of Expenditure dated 19th October 1994 and had completed 8 years of service as on 30th October 2000. As such, he was entitled to avail the scale pay of 5,000 to 8,000 recommended in accordance with the circular dated 1st June 2001. The respondent authorities had correctly placed him in the said scale. There's a mistake here. This should be 27th August 2001. However, subsequently, after a period of nearly 7 years, on the instructions of Department of Personnel, AN Administration, the pay scale of the applicant was revised to 4,000 to 6,000. While directing the respondent department to revise the pay scale of applicant from 5,000 to 8,000 to 4,000 to 6,000, personnel wing did not give any substantive reason for doing the same. This is besides mentioning that the pay scale granted to the applicant was done without any merit. Well, this is an erroneous finding in my humble submission. I had already read the letter. The personnel wing of the AN administration apparently took the decision of reverting the applicant to pay scale of 4,000 to 6,000 without referring to the circular dated 1st June 2001 and without ascertaining whether the applicant was indeed entitled to the pay scale of 5,000 to 8,000. My lord, I had already shown the letter which specifically refers to the circular. After reversion of the applicant to the pay scale of 4,000 to 6,000, applicant received first ACP upon completion of 12 years in the pay scale of 5,000 to 8,000 with effect from 30th October 2004. However, when the proposal for granting him second ACP was placed before the concerned DPC, the said DPC observed that first ACP in the pay scale of 5,000 to 8,000 was erroneously granted and next pay scale of after 4,000 to 6,000 was 4,500 to 7,500, not 5,000 to 8,000. Accordingly, matter was referred to the personnel wing of the AN administration to again confirm the view taken by the DPC. Thereafter, another 6 years, the applicant's pay scale was once again revised retrospectively on such and such in the pay scale of 4,500 to 7,500. We find that personnel wing of the administration did not take into account the fact that the applicant had been placed in the scale of pay of 5,000 to 8,000 in accordance with the circular dated 1st June 2001, since he satisfied the conditions laid down in the circular dated 1st June 2001, placement of the applicant in the scale of 5,000 to 8,000 was not at all a financial upgradation, but was revision of his scale of pay. The respondent authorities initially correctly placed the applicant in the said scale of pay. However, when the matter was referred to personnel wing, letter addressed the department for refixing the scale of pay of 4,500 without considering the fact that the applicant had been placed in the scale pay of 5,000 to 8,000 in accordance with provisions of order dated 1st June 2001. Then, my lord, a decision is cited. During hearing, my lord, the applicant would also place order of this tribunal at Jabalpur bench, which was taken on record. On perusal of the above circular dated 1st June 2001, it is clearly apparent that all those draftsmen in different departments other than Central Public Works Department who do not possess the prescribed qualification, excluding those who have already derived the benefits envisaged in OM dated 19th October 1994, were directed to be placed in the scale of pay recommended by 5th CPC on completion of minimum service as indicated in the memorandum. In the said circular, it has also been made clear that in determining the eligibility to be placed in the revised scales of pay, the service already rendered in the pre-revised scales will also be duly taken into account, and further that once the draftsmen in various central government departments are placed in applicable revised scales of pay, further promotions to higher scale grades will be made only against the available vacancies in such higher grades in accordance with the normal eligibility criteria prescribed in the recruitment rules. Thus, as per the aforesaid circular, and now the criteria for grant of higher pay scale to draftsmen in different departments, the person should be working as draftsman and have particular length of service. It is admitted fact that applicant is on the facts of that case. We are of the view that the case of the applicant is squarely covered by the above judgment. And then, my lord, the benefit. Now, kindly see, impugned order dated 5th December 2014 and order dated 4th January 2008 are quashed and set aside. Consequently, respondents are directed to pay arrears. Now, my lord, my principle, three submissions, my lord. First submission is that a mayor, if my lord will see the revision application of 14 January, the review application rather, which was made by the applicant, which is at page 110, will itself show that his grievance was only against 5th December 2014. His grievance was not against 14 January 2008. He had accepted 14 January 2008. He had no issues with the fact that he was treated to be outside the ambit of the circular dated 1st June 2001. His only grievance was that ACP of 5,000 to 8,000, which was granted on 14 January 2008, should not be disturbed. The CAT has gone behind that. The CAT says that even the 14 January 2008 is erroneous and he should have got the benefit under 1st June 2001. So the CAT is essentially reverting to 27th August 2001 position, which was at page 99. Secondly, my lord, the CAT says that the letter has no reasons. Kindly see, my lord, page 100 again for a moment. The personnel wing has given detailed reasons. The personnel wing has considered the of office memorandum of 1st June 2001. The CAT says office memorandum of 1st June 2000 is not referred at all by the personnel department. Kindly see page 100. There are detailed reasons which are given in this letter. Why be having already working in the proper pay scale, this person is not entitled to the benefit of the circular of 1st June 2001. That would apply to those who have been left out. So, my lord, this has not been considered at all. So, my lord, my humble submission is, my lord, the decision of the CAT is erroneous. And if your lordship feels that, my lord, this requires reconsideration, my lord, the matter can be sent back to the CAT also. In the meanwhile, my lord, they have proceeded in contempt. So, my lord, if my lord is not getting disposed of, my lord, then I will pray for some interim protection.
Is no content has been filed by. It is the extension application they have moved after the expiry of 45 days that I have shown your lordship is. Second point is, my limit sentence half on the letter written by the personal department. That is at page 100. In this page 100, this letter has been sent to me on 28th of September 2015. Letter was issued when? Letter was issued on 18th of July 2006. And the letter very categorically says at the bottom, it is forwarded on 28th of September 2015, page 101. Now, the last line of this order says, pay scale of the draftsman of your department as stated above, and a compliance report to this effect may be furnished to this administration at the earliest, but not later than 21st of August 2006. This will have done it, but what they have done on next letter, page 28. They have withdrawn the pay scale of 5,000 to 8,000, 102 in circle. They have withdrawn the pay scale of 5,000 to 8,000, which was awarded to me after 8 years in terms of the ministry circular. And they have placed me in the pay scale of 5,000 to 8,000. They have given me. And this recommendation, who has given? On the basis of the personal department. Personal department has very categorically stated, I'll take your lordship. Third paragraph, second paragraph, third paragraph on the page 101. However, the draftment of your department who is already in the appropriate pay scale of 4,000 to 6,000, eligible for part of the scale of pay of 5,000 to 8,000 as first financial obligation under the ACP scheme in terms of the DOPTOL. Now they have awarded it 5,000 to 8,000 after 12 years of service. And they have made the recovery, which I have paid from my GPF. After another 7 years, another there is a meeting. They say first ACP was awarded fraud. Now, most important factor is here the order which has been passed, that is of 1st June 2001. But before I take your lordship to this page, I would like to take your lordship to the page 93, the recruitment rules. 93. 93, June 3 is the rules for draftsman in Government Polytechnic Port Blair. Bottom. Name of the post is draftsman. Scale of pay is 12,000 to 1200 to 2040. Got it, my lord? Now, page 96. This is my appointment order. In exercise of the powers vested in him by the AN administration notification number such and such, the principal government polytechnic court where hereby appoints mine is the expert. At page 94, my appointment. In exercise of, in consonance with the orders of the Honorable Cat at Calcutta contained in Mr. Order 398 of 91 dated 3/6/1992. In the case of Sri T.K. Rai versus Union of India and others, the DPC considered the case of the candidates sponsored by the Employment Exchange along with Sri T.K. Rai in the meeting held on such and such date. DPC recommended the appointment of Sri T.K. Rai as draftsman in the department against the existing vacancy. Accordingly, Sri T.K. Rai is hereby appointed as a draftsman in the scale of pay of rupees 1200 to 2040 with effect from the date of reporting for duty, subject to the following conditions. So initially, I was appointed in the pay scale of 1200 to 2040. Now, kindly have a look at the order of 1st June 2001, which is page 97. Page 97. I would like to take your lordship to the page 98, relevant portion. The minimum period of service to be rendered by placement from the scale of pay of 4,000 to 6,000, pre-revised 1,200 to 2,040, to the scale of pay of 5,000, 8,000, within bracket pre-revised 1,400 to 2,300, revised to 5,000, 1,500 to 2,000. By 5th CPC, 8 years period is required. I was appointed in the pay scale of 1,240 to 2,040, 1,200 to 2,040. I completed 8 years. I joined the post on 30th October 1992. I completed 8 years. Now, 5th paragraph of the same letter. These orders shall be applicable to such other draftsmen in the various government departments who had not derived the benefits envisaged in the department's OM dated 19th October 1994 as on 1/1/96. Let them demonstrate that I have derived the benefits because I was appointed in the 1,200 to 2,040, revised to 4,000 to 6,000 because of the revision in the pay scale. I completed my 8 years of service. I was awarded the pay scale of 5,000 to 8,000 in terms of this OM. Now, how do they say I was appointed in some? There is one order is also mentioned here, why not? I just wanted to that is OA number 398 of 291, page 94. This OA I have filed because my case was not considered merely on the ground that I am a known local to the Union Territory of Andaman and Nicobar Islands. So my career in the life started with the going to the court, and now I have retired in the 31st December 2019, and still I'm here. So there is nothing wrong. The personal department itself has suggested that he should be given 5,000 to 8,000 with effect from 30th October 2004. But later on, after 7 years, they have realized, they woke up, no, this is wrong. And they again made the recovery. How the recovery has been made? Nothing is being informed. Nothing is being told to us. Another point is, this WBC has been filed by the kindly have a look at the affidavit. Affidavit is at page 19. I read out. Page 19. I, Sri Benia Varghese, aged about 50 years, son of so and so, resident of Lamba Line, Port Blair, functioning as administrative officer of Dr. B.R. Ambedkar Institute of Technology. And petitioner number 4. Do hereby solemnly affirm and state as follows. Whether he has been authorized by the other respondents, there is no whisper. Who are the other respondents? Other respondents can be seen from the first page, the Lieutenant Governor Andaman Nicobar Islands, Secretary Education. These are not there. He has not been authorized. Now, in the entire WPC, nowhere they have made any whisper that they have filed an application for the extension of time for the compliance of the order.
When was that application filed?
Application was filed 5th of July 2024. MA number 680 of 2024.
Fifth July 24.
5th July 2024. MA number 680 of 2024.
Do you have a copy of that MA?
Yes, ma'am. I have annexed it
Oh,
with
you
my
annexed.
affidavit in opposition.
All right.
It is annexed there at page 8. At page 8 of my affidavit in opposition. Page 8.
Yes.
Kindly have a look at this paragraph 3 and 4 at page 11. Personal Department of Andaman Nicobar Administration, after examining the case with reference to the CAT order dated 11th of January 2024 and the Ministry of Finance letter recommendation dated 1st June 2001, and is of the opinion that the applicant for the aforesaid OA is eligible for the benefit of the upgraded pay scale as envisaged by the Department of Expenditure, Ministry of Finance, Government of India, while recommendation dated number such and such dated 1st of June 2006. 1. Since more than 23 years has been passed from the issue dated date of the aforesaid recommendation, therefore it is appropriate to take up the matter with the nodal ministry for obtaining approval of the Ministry of Finance prior to extending the benefit of upgraded pay scale to the applicant. 5th paragraph. That time given by the Honorable CAT, White Order dated 11th of January 2024 is expired on 25th of March 2024. Due to the Lok Sabha elections 2024, the senior officials of the Andaman Nicobar administration were engaged in the election related work. Thus the delay occurred for filing the instant application may be controlled. Now, have a look at the verification has been signed in court of this circuit, which is at page 40. I, Sri Benia Varghese, aged about 55 years, wife, son of so and so, resident of Lamba Line, Port Blair, functioning as administrative officer, Dr. B.R. Ambedkar Institute of Technology, Pahargaon, Port Blair, and respondent number 4, do hereby state that I have been duly been authorized by the respondent authority to file this miscellaneous application on their behalf and fully aware of the facts and circumstances. Now there are other respondents, whether they have been authorized or not. These applications have been filed by the state. They are the protectors of the civil rights. And in support of them, whosoever invokes the Article 226 of the Constitution. They have to come with the clean hands, but they must disclose each and every fact. In the entire WPC, nowhere this whisper, my lord, your lordship whisper. I am relying upon the judgments of the Honorable HS Court, your lordship must be remembering. A.D. Sharma was the steel authority. I am relying on paragraph 28.
बोला ही नहीं उस बारे में
28. The above principles have been accepted in our legal system as per the settled law of the party who invoke the extraordinary jurisdiction of this court under Article 32 or of High Court. Under Article 226 of the Constitution is supposed to be truthful, frank, and open. He must disclose all the material facts without any reservation, even if they are against him. He cannot be allowed to play hide and seek or pick and choose the facts he likes to disclose and to suppress or not to disclose other facts. The very basis of the writ jurisdiction rests in the disclosure of true and complete facts. If the material facts are suppressed or distorted, the very functioning of the writ court and exercise would become impossible. Now, in the same paragraph 32, in Dr. Vijay Kumar Kathuria versus State of Haryana, it was the case of the petitioners that the provisional admission granted to them was not cancelled and they were continuing their studies as postgraduate students in the medical college on the relevant date. On the basis of the said statement, they obtained an order of status. The Supreme Court ordered inquiry and the district judge was asked to submit his reports whether the provisional admission granted to the petitioner were continued till October 1st, October 1982 or were cancelled. The report revealed that to the knowledge of the petitioner, their provisional admissions were cancelled long before October 1st, 1980. Thus, the petitioner made the false representation to this court and obtained a favorable order. Similarly, paragraph 35 is also important. In the case of Welcome Hotel and others, state of Andhra Pradesh, certain hoteliers filed petition in this court under Article 32 of the Constitution, challenging the maximum price of foodstuff fixed by the government, contending that it was unconstitutional and obtained a ex parte order. The price, however, was fixed as per the agreement between the petitioners and the government, but the said fact was suppressed. Similar is the case in the case of paragraph 37. In the case of agriculture and processed food products, 38. In the state of Punjab versus Torabpreet and others, A obtained relief from the High Court on the assertion that a test in the particular subject was not conducted by the state. In an appeal by the state, it was stated that not only the requisite test was conducted, but the petitioner appeared in the said test and field, observing that the petitioner was under an obligation to disclose the said fact before the High Court. The court dismissed the petition. So from this judgment, it is very clear. If somebody has not approached the Honorable High Court with the clean hands, the application is liable to be dismissed with a heavy cost. Another point is, the tribunal, yesterday I have shown your lordship one order. Of the passed by the tribunal where their MA was allowed. Where their MA was allowed.
This MA 680 has been allowed.
That has been allowed. If they could have disclosed this, I would have not come with all this. Kindly realize the person who is facing the difficulties at the age of 65. 2019, we are in 2024, going to lower.
ऑर्डर लगा
This MA has been allowed after the filing of this. And MA is allowed only because they have given an assurance before the tribunal that we will comply with the order. Otherwise, there was no reason, because the time period has already expired. And what has expired, that cannot be extended. Now, another judgment which I would like to place before your lordship, this is of the Honorable Apex Court, where 5 lakhs cost has been imposed by the Supreme Court. And also of the our High Court, this is a single bench order where Justice Rajwanda has imposed a cost of 10,000 for suppression of material. Page 100, already your lordship has seen. Personal department says awarding 5,000 to 8,000. It takes 8 years for them to realize, no, it should be post of 5,000. This is the working of the government administration, which represents the state. And being a government servant, one cannot make every time every representation against the authorities. Here, the typical problem is he will be transferred out. Disciplinary proceedings will be initiated. All these four.
My lords, I have 3 short submissions. First, my lord, my learned senior has said nothing on the merits of the case, whether 1st June 2001 is applicable or not, whether the government servant in question had acquiesced in the first revision or not, nothing on the merits. And a miscellaneous application in an appeal, my lord, it is settled law, my lord, in any appeal, in any appellate proceeding or proceedings akin to appellate proceeding, facts which take place subsequent to the passing of the order are not material facts at all. In fact, leave of the court is required to present any of the facts that have taken place after passing of the impugned order. A filing of a miscellaneous application, if at all, shows the virtue of the state that pending its rights to appeal, it is because the order exists, there is no stay on the order. So it is duty bound to take steps either to comply with the order or to seek an extension. Unlike a private party, which would perhaps in similar circumstances say that an appeal is filed, etc., the government is duty bound to follow, and the government, kindly see the order of the CAT at page 87. Kindly see the order at page 8. It is annexed with my rejoinder at page 87. This makes it very clear what was happening. 19th November 2024 order, which is passed on the miscellaneous application. Heard learned counsel for the parties. Today, learned counsel for original applicant has drawn our attention to order dated 11 January 24, wherein this tribunal had quashed the impugned order, etc., etc. Now, kindly see the third para. Learned counsel for the original respondent submitted that thereafter they have preferred WPCT, wherein no stay has been granted. Learned counsel for the original applicant submits that 45 days time as granted by his tribunal is already expired. Now the respondents are approached by filing MA for 6 months and then extension is granted. My lord, what wrong has the state done? We are acting perfectly in accordance with law. In fact, we are duty bound to act like this. We have filed a WPCT. The WPCT is pending before the Honorable High Court. There is no stay. So we are duty bound to treat as if the order is in existence unless it is varied or modified or stayed by the higher court, which in this case is the Honorable High Court. So how can fault be found with the administration for actually giving respect to a court order unless it is of the lower, not the lower, the court order of the authority, which is yet to be stayed by the Honorable High Court. My lords, if at all, my lord, this is the correct procedure which should be followed in a situation where simply and rather than just filing an appeal and taking adjournments in the court below, we have done the correct thing by informing the court that there is no stay, but we kindly give us an extension. Of course, it is subject to our rights in appeal. How can that be disturbed? And my lord will see the miscellaneous application. What does the miscellaneous, again, the miscellaneous application which they have annexed with the affidavit of opposition. What does it say, my lord? In paragraph 3, it says that personnel department is of the opinion that he is eligible. Then it says more than 23 years have passed. It is required to take up the matter with the nodal ministry for seeking approval. So if at all this is tentative, my lord, in any case, this does not, there cannot be an estoppel against a right to appeal, my lord. We have preferred an appeal. And this is a subsequent, if there was an admission shown before the passing of the impugned order and we had suppressed that, yes, that would amount to suppression of material facts. Subsequent to passing the impugned order, pending any decision of the appellate court, if we are seeking an extension, there is no suppression at all. And my lord, the whole issue here is, my lord, nothing has been stated so far as the merits of the matter are concerned. The complete argument is based on this application which has been filed, which is subsequent to the passing. An order has to be defended or on the basis of facts which were in existence when the order was passed. It cannot be sought to be defended on events which have taken subsequently. So, my lord, that is my humble submission. And lastly, one second. Lastly, with our rejoinder, we have annexed all the file notings. There is nothing that we have hidden, that a decision was initially taken, then later on it was reconsidered. The detailed file notings have been recorded at pages 52, 76 of the rejoinder. We have disclosed everything, my lord. Page 52, my lords, even the decision earlier, why it was taken to file the extension application, because they were under opinion that there is a limitation to file a WPCT. Then, my lord, eventually, my lord, the decision to file the appeal is also recorded at page 87. We have
Very well.
My lord, I have already submitted on merit. I was appointed in a pay scale of 1200 to 2040 by an order.
Heard
I completed
submission
8 years.
heard
I have not availed
submissions
any benefit of the 1994
made on behalf of both the parties.
96.
Let the matter appear in the list marked for orders on 11th of December.
19th January. Time
Item number 4, WPCG 44 of 2024.
Worship, after going through the records, I find certain documents are not there. I want to file a supplementary affidavit, Your Worship.
WPCT supplementary.
Some papers which were there before the tribunal, those papers are not there here.
Please come.
By the supplementary annexing.
It has been submitted by the learned senior counsel representing the petitioner that certain documents which were filed before the learned tribunal has inadvertently not been annexed in the writ petition. Stop prayer has been made for allowing the petitioner to file a supplementary affidavit. Stop. Prayer sought for stands allowed. Stop. Let supplementary affidavit be prepared and circulated by
1 week, Your Worship. Already it is there, just I have to file it.
by 12th.
Well,
List in the next available circuit.
Item number 5, 67 of 2024.
I'm for the petitioner.
I'm for the respondent.
Your Lordship, the case here is very short point is involved, Your Lordship.
Is there any stay application? Did you file any stay? Only the memo.
Only the,
All right.
Your Lordship, order was passed by the Honorable, I have preferred an appeal challenging the order passed by the Municipal Council for demolition before the Deputy Commissioner. The Deputy Commissioner was not disposing of the appeal and the Municipal Council was bent upon implementing it. I approve this Honorable Court directed a Deputy Commissioner to dispose of the appeal within a specified period of time. The Deputy Commissioner issued a notice asking both of us, both the Municipal Council and the applicant, to submit the written documents. Documents which is relied upon. Documents have been submitted by us. We don't know whether they have submitted or not, we don't know. Thereafter, a date was fixed for hearing. 18th March 2024 was the first date when Deputy Commissioner was not available, specifically contained. Next date was on 21st May 2024. On that particular date, an adjournment petition was filed stating that holidays are going on, council is not available, so kindly fix it on any day after 5th June. One application, adjournment application was filed. Suddenly on 31st July 2024, we are coming to know that an order has been passed dismissing our. My contention is that we wanted only time after 5th June any day. When you are thinking of passing an order on 31st July 2024, one hearing could have been given to us. I can understand if the appeal is dismissed on 21st May itself, rejecting my adjournment application. But when you can wait up to 31st July to pass an order of dismissal, one hearing could have been given to us. And when my adjournment application is on record, that is the only point.
No, but then the adjournment application was not allowed. This is what the court records.
We don't know what happened on that particular date. The adjournment petition was submitted. And then what order was passed, it's not known. And learned single judge observed, Your Lordship, that written submission was submitted by the Portland Municipal Council and opportunity was given to us also to file written submission. That is not the case at all. Not at any point of time in any of the notice, the Deputy Commissioner asked us to submit the written submission. And we have not got any copy of the written submission of the PBMC also. We don't know whether it has been submitted or not. That also we don't know. Because PBMC, as per our knowledge,
What is the
I am
position
on
now?
behalf of the Deputy Commissioner, my lord. If my lord sees the order passed by the Deputy Commissioner, it is there, my lord, that PBMC has filed the written submission.
we have not got any copy of
And
that.
because they did not choose to appear before the appellate authority. They have filed the appeal and they sat over the matter that they did
Time
not
and
choose-
again,
Yes, they are filing adjournment
adjournments-
time and again they are.
Adjournment sought for.
Yes. That is the
Lordship,
case.
we not sought for time, only once we sought time, on 21st.
Because this appeal has been preferred before the
Your
deputy
Lordship, the time
commissioner
is
against the
only once.
demolition order.
It is at page number
So after filing of the appeal, my lord,
95.
they sat over the
Achha.
matter. They
The
did not
petition is
choose
not
to
there.
appear,
No, no.
neither they filed
Your
their
Lordship, it's
written
one
submission.
specific case that
Only
one day was fixed
PBC
for
has
filing
filed a
written
written
documents.
submission.
See the court's order, I can see the case was fixed, second paragraph on 18th of March.
Yes,
It
that
could not be
deputy
taken up,
commissioner was not there.
could not be taken up.
Yes,
21st of May,
that is the only date we did not.
petitioner sought for an
That
adjournment.
is one adjournment, that's it. That is the only adjournment. No other adjournment is. One adjournment. It is not that time and again we sought adjournment. First date, written documents submitted. Second date, deputy commissioner was not there. Third date, we have sought for adjournment, only once.
What is the position? Has the demolition order been acted upon?
No, no, no.
No, not yet.
Because it's 11th of December 2023, it's
Yeah.
nearly 1 year.
1 year, but it has not been acted because
Not that-
PBMC is not being made as the party. I am only, the deputy commissioner was the party.
Because
In
appellate
this,
authority, he is the appellate authority. That's why deputy commissioner was only, it's a matter relating to opportunity of hearings.
since
So how the PBMC will be relevant? It will be helpful if I had made PBMC as a party.
whether the
Because they- by
demolition
saying the
order
appeal is
has
pending, They will
been,
not implement the order.
they're going to
But I'm
execute the
not-
demolition order, that PBMC have to answer, but he's not the party to the. PBMC is not the party to this appeal. Miller. Even in the writ petition also, only the deputy commissioner of
Building
the
has
party.
not been demolished. I am seeking only one opportunity. I will argue the matter and finish up the matter. One date can be fixed, your lordship, on that particular date hearing can be done. If on that date I am not appearing, the order would remain like that.
Please come. The order dated 8th November 2024, passed by the Honorable Single Judge, dismissing the writ petition and affirming the order passed by the Deputy Commissioner. Dated 11th December 2023. No, dated 31st July 2024 is impugned herein. Stop paragraph. The order of demolition dated 11th December 2023, passed by the Municipal Council, was carried in appeal by the petitioner before the Deputy Commissioner. Stop. The Deputy Commissioner fixed the appeal for hearing on 21st May, on 18th March 2024, when the same could not be taken up. Stop. The matter was refixed on 21st May 2024, when the petitioner asked for an adjournment. Stop. Without granting any adjournment, the Deputy Commissioner, being the appellate authority, passed final order on 31st July 2024. Stop. The paragraph, the petitioner submits that only one adjournment was sought for by the petitioner before the appellate authority. That is on 21st May 2024. The appellate authority kept the petitioner's prayer for adjournment pending and passed final order affirming the order of demolition on 31st July 2024. Paragraph, it has been submitted that one opportunity may be granted to the petitioner to press her appeal before the appellate authority. Stop paragraph. Learned advocate representing the deputy commissioner submits that the order of demolition was passed on 11th December 2023. Stop. The petitioner ought to have been more vigilant and ought not to have sought for an adjournment, but should have proceeded with the appeal diligently. Stop paragraph. The deputy commissioner did not commit any error in not allowing adjournment to the petitioner. Paragraph. We have heard the submission made on behalf of both the parties. Stop. It appears that admittedly order of demolition was passed on 11th December 2023 and the appeal was disposed of on 31st July 2024. Stop. Till date, the order of demolition is yet to be executed by the municipal council. Stop paragraph. The court is inclined to accept the submission made on behalf of the deputy commissioner that the petitioner ought to have been more vigilant in proceeding with the appeal. Paragraph. Nevertheless, for ends of justice, a further opportunity may be granted to the petitioner to press the appeal. Stop. Paragraph. It is directed that the appeal preferred by the petitioner before the deputy commissioner be reconsidered by the authority at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop paragraph. It is made clear that no adjournment will be granted to any of the parties. In the event adjournment is sought for, the deputy commissioner shall decide the appeal on the basis of the documents already on record. The order passed by the impugned order dated 8th November 2024 is accordingly set aside.
And also the order of the appellate authority. Otherwise, Your Lordship,
The order of the appellate authority dated 31st July 2024 is also set aside.
Give me your-
Okay.
Item number 6. Limit is 70 of 2024.
Just now to see. Only memo opinion.
Your Lordship, this appeal has been filed challenging the order of the learned single judge. Your Lordship, where the learned single judge has relegated the petitioner to go before the labor court. So that this is the issue. Whether there are
Disputed questions of facts arise, how can the writ court go
These are
into?
not disputed questions of that, Your Lordship, I can satisfy. I will file a paper book for Your Lordship, it can be heard on the base materials available. I will
Only-
place the writ petition.
There is no stay petition, so the
I have not
documents,
filed any stay.
documents will have to be brought on record.
Otherwise, how can the validity of the order be looked into?
Your Lordship, I will file a paper book, informal paper book, Your Lordship. Because affidavit in opposition and reply was filed before the,
Was filed.
yes.
What was your prayer? Re-engaging the petitioner as DRM.
Yes, Your Lordship. Because Your Lordship, he was involved in a criminal case. the authorities have asked the petitioner to give an undertaking that past service he will not claim, and then they will re-engage. That was the letter given to the petitioner. Petitioner gave an undertaking, despite such fact they have not taken. Where is the disputed question of fact? These are all on records.
So the petitioner right now is no longer in service.
No longer in service. I have not paid for any interim orders.
There is no scope also.
Yes, Your Lordship, that's right. I'll file an informal paper with Your Lordship.
What
I
is
can
your
bring all the
submission?
documents.
What is your submission?
Let the documents be brought, we cannot defend the order without the writ and affidavit in opposition. Man.
The order dated 13 November 2024, passed by the Honorable Single Judge, is impugned in the instant writ petition. Stop. The documents placed before the single bench be filed by way of an informal paper book by 12th December. List the matter in the next circuit.
Right.
My lord, item 7, my lord, I beg to appear on behalf of NHIDCL. My lord, there was a direction passed by the honorable bench on the last 6th November that this matter is expected to appear on 6th December. My lord, it is appearing today. I'll only, my lord, beseech your lordship, my lord, if your lordships can take it up on 6th December.
There was a direction, my lord, on the administration to file a report and those officers to be present, my lord. They are present here. If my lord, their report can be taken on record and my lord, their presence can be dispensed with. That is the only.
The last order said 6 now.
6th of November. Why has it been listed today?
6th December.
6th of December. Why today? Today is only 4th. It has come in advance. What is to be done?
No, only thing, my lord, this is principally, my lord, this is concerning the NH4, my lord, which is being construction of is being carried out by Mr. Shanal's client NHIDCL. However, on the last occasion and from time to time reports, etc. are filed. But on the last occasion, my lord, the Honorable Court directed also the APWD, which is responsible for other roads in the islands, and the PBMC, which is responsible for the municipal roads in the Port Blair town.
The special officer's submission has been recorded that no roads have been laid down at all.
That is regarding.
Do we hear it today or on the
My lord,
6th?
that is,
The date
yes, my lord,
Only
my
by
lord, we'll file a report to that extent.
only request is, my lord, that
The
is
work that has been done.
however, my lord, so far as PBMC and APWD, my lord, their officers are present, my lord, their presence
Let
can
them
be
come once.
Very-
Because I do not know what is the reason for their, why they have been called for. We have
very
not
well.
gone
No,
through the
we'll come
fact.
again tomorrow.
Yes, yes. List on the scheduled date.
My 6th, on the 6th, day after tomorrow, my lord.
Yes, yes.
6th. I'm grateful, my lord.
Item number 9,
Copy has.
Deputy 5 of 2023.
He mentioned the matter. Chennai for treatment. Oh, it's a 9.
8.
When is the advocate due to come back?
9.
When is the advocate due to come back?
Maybe a week.
1 week. An accommodation has been sought for on behalf of the learned advocate representing the appellant. Stop. List before the next circuit.
Right.
Item number 10, CRA DB 5 of 2023.
Target number 5, 6, and 7. My signatures to go in the pairs. Not waiting for 1 and 2. Actually, they are. The prosecutor is also engaged before district judge. Let it be passed over for short file.
Passover cannot be given. The bench will rise. The list is nearly over. So it is adjourned for the day. Monday. Monday.
Lordship.
By consent of the parties, list the matter on 9th.
Obliged.
Item number 11, WPA 103 of 2023.
For the writ petitioner, my lord, we have to file a reply. The writ petitioner is based out of Northern Middle District. Mayavandar, Diglipur. So we had spoke to him. He could not come in the first week. He has promised to come in the next week. We need his signatures to filing reply. Next week we'll file a reply. Let it be like Wednesday or next week.
Learned advocate representing the petitioners seek time to file the affidavit in reply. Stop. Let the reply be prepared and circulated by 12th. List in the next circuit.
Correct, my lord.
Item number 12, FMT WC 1 of 2024 with item number 13 and 14.
Lordship, item number 12, 13 and 14, Lordship, can it be taken up on Monday because learned advocate Mr. R. Arun Peter is appearing. He is having some personal difficulty.
Monday, we have fixed up quite a few matters.
Let it be Tuesday.
Let it be Tuesday.
It will be at the request of the respondent in item number 12. Respondent number 1 in item number 12.
Lordship.
You are there.
No, he is the, I am the petitioner in item number 12 and he is the,
13 and 14.
Mr.
and the-
request is being made on behalf of the respondent number 1 in item number 12.
All right. On the prayer made on behalf of the record for whoever he is appearing. For listing the matter on 10th.
Obliged, Lord.
Item number 15, FMT Award 2 of 2024.
My lord, Mr. Rakesh Kumar is for the petition, my lord. He is, my lord, on his legs, my lord, I think in certain contempt matter, my lord. So, my lord, I am praying not today, my lord.
On the prayer made on behalf of the learned advocate representing the appellant, the matter stands adjourned for this week. For this week.
Great.
Is it ready, madam?
Very well. Next week we'll take up.
Eventually not in the list.
And then after the consent of application also taken up. So last whatever department for the August 2023. Now it has to be taken by. Okay. For
Actually, before this appeal was allowed and the matter was demanded.
and against that appeal has been filed. The hearing is has to be taken up. All right. Manoj, are these matters there in the combined list that he was published? মামলাগুলো কি আছে? দেখে নিন, যদি থাকে তাহলে তো আর কিছু করার নেই, না হলে দিয়ে দেবেন।
Item number R.
This is the things they have to professional after participating in the tender, being successful, completed the work of the department, and is waiting for his report. Do you know, sir?
Yes,
It's more disputed questions of facts in actually.
isn't anything admitted? Did the petitioner perform the work?
Petition, there are several work orders that have been included.
All right.
And there are various items. Some petitions for that.
Why all you put it in one writ petition? It will be difficult for the authority to find it out.
Person, your lordship.
Maybe the person is single, but the work orders are different. And it's of different places also. He says one is Rangat, one is Digripur, or what are the places?
Branches.
Maybe.
Down that.
Have you made a representation before the authority seeking payment? Where is it? Please show me.
Page number 322.
322 is a Government of India communication to the Chief Engineer. Page 332, I can see one.
317 also, when the authorities have asked that the documents, it was supplied to them. 317.
Request to furnish additional documents. Did you submit?
Yes, sir, all documents submitted. And then, kindly see 322 is the response to that. A joint meeting was called. Legal notice was also issued to them. On 6th May 2024, reference is there in their own letter. I'm just placing that one with reference to the letter cited under reference to.
Please come once. The petitioner seeks payment.
4 point.
Please wait, please wait. The petitioner seeks payment of the work performed by it in accordance with the work orders issued by the Ministry of Ports. Is it the Ministry of Ports, comma, shipping and waterways? Stop. Learned advocate representing the respondent authorities is directed to prepare a report apropos the claim of the petitioner. By within a period of 4 weeks and circulate the same. Stop. Let the matter appear in the next circuit.
One more. Page 287 is one work. 287 is 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 2 has been done for the director of RT and PRI. They have to add the RT and PRI. They have to-
You only file your report in connection with the work which has been done in respect of your department. You cannot take responsibility of some other department.
They have added the next
You do not, you mention,
department.
very well, you mention that this is not in your department, your report will say so.
I had no connection with RD. Because by them only the contract was given, I performed, but now they are saying that it was the work of RD.
Very well. File a report and
father expired. So sons got the license. The manual records of right sketch map was given by the authority, but it was not computerized, my lord. The adjacent plot holders, their name is there in the computer record, but my name is not there. I have given a representation on 9th of September 2024, my lord.
page,
It's at page 26, my lord.
this has not been considered.
It has not been considered, my lord.
What is the provision?
My name
for
was-
this computerized system? From the manual records, you just update in the
No,
computer?
we have to check whether,
Verify.
yes, we have to verify whether the land has been actually occupied by the person who has been.
But then she
Given
says
with
that
the
the
license.
license is already there. It in the manual records, it is recorded.
Yes, my lord.
Fine.
I have annexed along with this.
Please check
representation
up.
also.
Please come. The petitioner's prayer for updating the records in the computerized record of rights is pending consideration before the Tehsildar,
Tahsildar, my lord.
Port Blair. Stop. Without any paragraph, without entering into the merits of the same, merits of the claim of the petitioner. The instant writ petition is disposed of by directing the Tehsildar, Port Blair, the respondent number 2 herein, to take necessary steps in accordance with law to consider and dispose of the prayer of the petitioner at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. It will be open for the Tehsildar to verify the records prior to updating the same. Stop. An opportunity of hearing may be granted to the petitioner for production of all documents in support of his claim. Writ petition disposed.
Obliged.
Item number 3, WPS 667 of 2024.
My lord, short pass over maybe given.
Behalf of the
Senior,
respondents, my lord.
Mr. Arul Pasant is appearing for petitioner.
Lord, this matter, it has to be heard in affidavits, my lord. Since it is his case that they have been issued with a license and we have not accepted the premium. So it has to be seen whether they have given the premium, because in the license, if my lord comes to page
Let it be
45,
fast forward for the time being.
because today is the first day, I have to take instruction in the matter whether they
Then
have,
take instructions and come back.
my lord. Because if it requires to be heard in affidavits,
Then it is all right.
Then
But then you at least go
otherwise
through
it
the
can be
papers
disposed
and
of.
then come back. To allow the learned advocate representing the respondents to come ready with proper instruction in the matter. List the same on next Tuesday, 10th, or thereafter,
on Wednesday,
11th,
11.
11th.
Obligation.
Item number 4, WPS 629 of 2024.
Lordship, generally I used to appear on behalf of the respondent authority, Lordship, whether they have served the department or not.
My lord, for item number 4 to 8, Mr. Prakash Minj is appearing for the petitioner. I pray for a 1 week time, my lord. This matter may be fixed on Monday.
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 on the prayer made on behalf of the learned advocate representing the petitioner. List the matter on 9th.
My lord,
Stop. Let copy of the writ petition be served upon the learned advocate representing the respondent, if not already served.
my lord,
4 to 11,
4 to 8, my lord.
4 to 8. All right, 4 to 8, same order.
Item number 9, WPS 632 of 2024.
My lord, I am for the petitioner.
I am appearing on behalf of the respondent. I have the copy.
What is the matter?
My lord,
For
it's
grant
a
of
grant
electricity.
providing the electricity.
Where is your application?
Annexure P1.
Consider and dispose of.
Lordship, one thing is there, I want to make the submission, Lordship, I have received the report. Already where the petitioner is claiming the electricity connection,
There is a connection.
there is a connection. In the
Intimate,
name of her father.
intimate the petitioner.
Lordship,
My lord, small submission, my lord. Petitioner has a writ petitioner. It is not in the name of the writ petitioner. It is in the name of the father.
they
my lord.
are the
You are,
encroacher, Lordship.
you are enjoying electricity from there. What is the use of a separate meter? To show your right that I am occupying.
I am residing in the dwelling house.
And what is your father doing?
My father is residing in the other house. It's just adjacent to that house.
Are you aware from are you enjoying electricity now? From your father?
Yes, ma'am.
The petitioner's application seeking new electric connection is pending consideration before the electricity department. Stop paragraph. The petitioner prays for consideration of the said application. Stop. Learned advocate representing the department submits upon instruction that the petitioner is already enjoying electricity connection from the electric meter standing in the name of his father. Stop paragraph. The department is directed to intimate the petitioner the fate of the application at the earliest. Stop. If the department is of the opinion that new connection may be given to the petitioner, the same shall be accorded in accordance with law. Stop. The communication, not the communication, the fate of the petitioner's application shall be communicated to the petitioner at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Must let the petitioner know whether he is entitled or not. If entitled,
Yes, they will
then
provide.
give.
Item number 10, WPS 635
Lordship,
of
10 I have to take inspection. Just today morning, my brother. have
For the
taken
writ
over the
petitioner.
plate.
For the writ petitioner, yeah, my lord. Affidavit of
Yes.
service is filed. Actually, I have sent the learned counsel a
Let me take
copy.
the inspection. Let me take the inspection.
What is your prayer?
I'm seeking electric
Grant of
connection I'm residing on a 100 square meter of land situated at Bamboo Flat. So,
Where is your application?
on page number 10, annexure P2.
Why can't you consider and dispose of? Or what will you do by taking instruction? Let the petitioner know whatever the fate of the application is. Because the court will certainly not pass order.
Lordship.
or grant
That's the difficulty, my lord. See, regulation says ki you have to dispose of the application within 30 days.
Yes.
I had filed my application on 9th of
Right.
August.
Just
In action.
the petitioner's application seeking new electric connection is pending consideration at the end of the electricity department. Stop. Without entering into the merit of the claim of the petitioner to obtain new electricity connection, the instant writ petition is disposed of by directing the electricity department to consider and dispose of the petitioner's prayer in a petitioner's application in accordance with law at the earliest, but positively within a period of 30 days from the date of communication of this order. Stop. The fate of the petitioner's application shall be made known to the petitioner immediately thereafter. Stop. If it is found that the petitioner will be eligible to obtain new connection, then the same shall be provided to the petitioner at the earliest, subject to compliance of all statutory formalities. Disposed.
Grateful, my lord.
Item number 11, WPS 639 of 2024.
I am appearing for the respondent.
Petitioner is not here.
No.
None appears on behalf of the petitioner. List the matter on. When next week?
Monday.
Monday, 9th. Take instruction if required in the meantime.
I have the instruction.
Very well.
Item number 12.
Same order.
WPS 641 of 2024.
Same order. Item 13 also same order.
Item number 14. WPA 643 of 2024.
My lord, I am appearing for the writ petition.
Yes.
Item 12 में आपने 14.
14.
Lordship, I am appearing on behalf of the respondent. I have received the instruction, Lordship. Here also, there are two electric connection in the house of the petitioner, in the name of her father.
My lord, no electric connection is provided in my name, Your Honor. And I am living in a separate dwelling house, Your Honor. My lord.
Very well, please come. One earlier order was passed. The electricity connection is there in the name of the father. Only that line is to be changed. Learned advocate for the electricity department submits upon instruction that the petitioner is enjoying electricity from two separate meters at the same premises. This is your submission?
Lordship.
Same premises?
Same premises.
Very well. The rest of the order remains the same. Dispose, they will let you know. And the period will be 30 days.
Lordship.
Period is 30 days.
Item number 15.
Same
WPS
Lordship.
644.
I am appearing for the
Same
writ
house.
Same house, 2 meters.
Two sister.
All right. Same order will go in 15 also. 14 and 15 same.
My lord.
Item number 16. WPS 646 of 2024.
I
None
am
for the
appearing for
petitioner.
the respondent.
None for the petitioner. List the matter on 9th.
Obliged.
Item number 17. WPS 662 of 2024.
Some personal difficulty of my senior, this matter can be taken up on Monday, by the way.
Why you are here? Why don't you proceed?
Don't have any instructions to do this one, just Monday, we are praying.
Very well. An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop list on 9th.
Item number 18. WPS
May I
6.
please, my lord?
18 and 19, Lordship, I have no copy, Lordship.
I have already served on 2nd of December, my lord,
Give a copy to your learned friend. I'll make it not today. Okay, tomorrow,
tomorrow.
let the matter appear
Let
in the
it be
list.
on Monday, Lordship. Let me take instruction also whether he is having the electric connection. or not.
Learned advocate representing the respondent authority seeks time to take instruction in the matter. Stop list on 9th. Serve a copy in the meantime.
Item number 20.
I don't have a copy. If a copy can please be served.
I'm serving a copy here.
Rajesh.
Already served.
No, but then he needs to go through it at
To go
least.
through, yes.
When? Next week?
My lord.
Next Wednesday?
Monday.
My lord.
Monday?
Monday, please.
To allow the learned advocate representing the respondents to come ready with instruction in the matter, list on 9th.
Obliged.
Item number 21. WPA 256 of 2021.
My lord, I am appearing for the petition.
Yesterday,
Yes.
my lord had my lord indicated to take instructions on whether my lord, this matter can also be disposed of in terms of this order dated December 21st, 2023.
Yes.
Now, my lord, here, my lord, per se, my lord, this, my lord may not record my consent, but my lord, it can be disposed of. But only thing is, my lord, my instructions are as my duty to the court, my lord, to inform that according to the respondents, nothing is due, but my lord, this exercise can still be carried out because this order also says arrears of salary as due to the petitioner as on date. So there is no difficulty. Let there be application of mine. They'll change their.
Because, my lord, in both the case, facts are similar. I have brought the writ petition of the other case also. Absolutely same. One line is also not missing. So, my lord, Same prayer, my lord, let them,
Please
Can be done, my lord.
my lord, that
The
order, my
petitioner-
lord.
The petitioner prays for release of arrears of salary on and from October 2020.
No, no, my lord. On and from, because by a subsequent order, I have corrected, my lord, that is from May 2021 to October
From
2021.
May 2021 to October 2021. Is it like one? May 21 to October 21. With interest. Stop. The prayer of the petitioner is pending consideration at the end of the respondent authority. Stop. Without entering into the merit of the claim of the petitioner, comma, the instant writ petition is disposed of by directing the respondent authority to consider the prayer of the petitioner for releasing the arrears of salary for the period May 2021 to October 2021.
My lord, if as due, my lord.
In accordance with law at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Stop. Next. Prior to passing a final order in the matter, the authority shall verify its own record to ascertain the dues of the petitioner. Stop. The payment shall be made along with the applicable rate of interest. Writ petition stands disposed of.
Obliged.
My lord has not indicated any time
4 weeks.
for.
There also it was 4 weeks. That is the reason I stuck to that.
My lord.
Item number 22, WPA 133 of 2022.
My lord, I am appearing for the petitioners, my lord.
Yes.
These petitioners, my lord, they were engaged.
Why they? I see one only.
My lord, it is through the union, my lord. Actually, that is wrongly written, my lord. Rajesh Pal and others. There are total 51, my lord.
All right.
Now, my lord, these petitioners were engaged.
From the very beginning, I see it's only Rajesh Paul.
Yes, my lord.
Others are not mentioned. No. Oh, I see
False memo of party.
the petitioners is Rajesh Paul and others.
My lord.
Represented by the president. Why? It should have been mentioned who are the others.
No, my lord, before the labor code, my lord, union has represented there in their claim petition, the names are there. Because when union is representing, my lord,
This is from the order of the tribunal.
tribunal,
All right.
my lord. My lord,
Cause title before the labor court was also the same, Rajesh Pal.
my lord, when the union is representing, my lord, because that has been done by not by a persons from legal background. So union represent, they say that
All right.
altogether 51 was there, my lord. It is there in the reference also and in their conciliation proceeding also.
All right.
My lord, here, the case is that these petitioners worked from 2007 to 2018 continuously as a daily rated employee under the electricity department. Now, my lord, one fine day they were removed from the service. Now, my lord, since the affair is governed by the Industrial Dispute Act, which warrant that if a person work for more than 240 days in a calendar year under section 25B of the Industrial Dispute Act, my lord, mandatory requirements are there under section 25F, 25G and 25H, which says that unless a notice is issued, you cannot remove them. That ought to be an illegal termination, my lord. Now, my lord, challenging the same, they filed a conciliation before the conciliation officer. Conciliation ended in failure. Thereafter, the conciliation officer submitted a failure report. Appropriate government refer the matter with the reference what is to be adjudicated. On the basis of the same, my lord, we filed a claim petition. They filed their reply. We filed rejoinder before the trial court. We adduced 5 witnesses, my lord, 3 to 5 witnesses. We examined before the trial court. The authorities examined 2 witnesses before the trial court. On the basis of that, subsequently, this judgment was passed. Now, my lord will find. First, I am placing the award, my lord, and thereafter I will place the orders, my lord. The depositions. My lord may kindly come to. Award starts from page number 88, my lord.
Yes.
First, my lord may kindly see the award is dated 30th March 2022. Now, my lord, kindly come to page 89 is the term of reference. The reference is whether the action of the Superintending Engineer, Electricity Department, Port Blair in retrenching the service of Sri Rajesh Paul and 50 others are legal and justified. Now, my lord, I am just reading the case of the workmen, my lord. The first 40 workmen filed statement of demand on such and such date. It revealed that they were working as daily rated Mazdoors under the second party. The nature of work was regular in the electricity department. It is stated that all the workmen are resident of Port Blair and Fararganj and were posted at different place under the direct supervision junior engineer of the concerned area. The work continuously from 2007 till 2019, my lord. However, the second party employee disengaged them from service with effect from 1st of July 2019 without giving any reason for following the statutory provisions. They stated that the Assistant Engineer Electricity Department issued certificate of service to some of the workmen indicating their continuous service in the department without any break. It is stated that disengage was done with intention to avoid the benefit of 1/30th of pay plus DNS allowances to be extended to the DRM working under the administration. Pausing for a minute, my lord, an order was passed by the administration on 22nd September 2017, whereby the administration has decided to accord the benefit of 1/30th of to all the DRMs who are discharging the duties of a regular employee. And my lord, that was pursuing because there was a court case and all. So they apprehend that then they have to pay this benefit to these workers also. Therefore, they have removed it. It is stated that after removing the workmen, second party engaged a large number of DRMs. My lord, kindly have a note of it from Andaman Public Work Department and deployed them for the work. When a workman is discharged from service, he would be the last person in the set cadre. If after his disengagement they engage anybody else, that would be violative to section 25G and 25H of the Industrial Dispute Act. It is stated that the second party failed to obey the instruction of such and such, wherein it has directed that the present number of DRM in his department should be frozen till further order. It is stated that number of DRM under the administration has extended the benefit of so and so. It is further the first party are entitled for such benefit. It is stated that the second party did not comply with the provision of section 25F, 25G and 25N of the Industrial Dispute Act. It is prayed that the disengagement of first one be set aside and that we directed them to pay back wages so and so 1/30th. Now, my lord, the name of the first party workmen are narrated, my lord. Second party files statement on 2nd December 2020. It reveals that the Andaman Nicobar administration has allowed the electricity department to obtain manpower from the tribal captain so and so on mandate basis for repair, maintenance, establishment and construction of such and such power house at isolated location under PMGYS as per requirement and availability of fund. It is stated that accordingly the second party engaged unskilled manpower on mandate basis as and when required from 2009 from village pradhan and tribal captain. It is stated that the second party never engaged any person directly in on any form except stated above. It is, my lord, if for argument's sake, if at all I am not engaged under them directly, then also if my lord sees section 21 of the Abolition of Contract Labour Act, my lord, there it categorically said all the responsibilities of the principal employer. Though that is not the case, but I am just submitting, my lord. A mandate and consolidated payment check of these mandates were issued by Pay and Account Office and disbursement were done in the bank and transferred to individual account of beneficiary engaged on mandate basis. It is stated that this practice started from 2014 and final disbursement of benefits were made by the Pradhan as done by MRI scheme Jovi. It stated that the question of continuation or discontinuation were not applicable in the instant case. It is stated that the executive engineer, based on the requirement furnished by superintending engineer, electricity department, and after obtaining due sanction from the competent authority, the number of mandates required were required to be taken from respective pradhan based on the requirement received from various division of the electricity department. Approval for the mandates were taken from the competent authority. So and so. It is stated that the workmen were mandate basis and not as DRM. My lord, any nomenclature that you have extracted my service for regular employee. In my lord Jagjit Singh, paragraph number 55, it has categorically stated the nomenclature is absolutely irrelevant, my lord. Thereafter, it is stated that manpower from so and so, consular with Manrega as mandate and cannot be considered as D1. They are not directly engaged by the department and therefore cannot claim for reinstatement. It is stated that the second party never maintains service record of the manpower engaged on mandate. It is stated that the same way not been DRM, the workmen are not entitled for so and so. It is stated that the Andaman Nicobar administration took a decision that there was surplus DRM in the APWD department and it was not possible for them to remove the service of the DRM, and therefore it took the decision to shift them to the electricity department in place of outsourced mandate workers. With respect to the certificate of second party, it is stated that the said certificate were issued only for the purpose of showing their experience to apply for any government job, and it doesn't reveal that the first party has engaged at DRM. It is stated that the workman cannot claim seniority at par with the DRM and therefore the circular is not applicable. It is stated that the implementation, my lord, by that circular, my lord, the Lieutenant Governor has stated that the workers who are working there, they have freezed it, that no further DRM should be engaged and at the same time they cannot be terminated. This was the circular. Now, my lord, the rejoinder, we have filed the rejoinder, workmen filed rejoinder on so and so, whereby it is stated that the workmen were receiving their monthly wages from the second party through bank payment. The second party prepared the wages bill and submitted to the pay and account office who passes the bill, and the wages were credited in the individual account of the workman. Workmen admitted that the workmen were engaged on the basis of the recommendation made by the Pradhan, but the role of Pradhan were limited to only recommendation of the name to be engaged as DRM. Evidence, my lord. First party examine such and such. Total 6 witnesses were examined, my lord. They were cross-examined, first party exhibit 1 and 2. Second party examined DW1 and DW2. Point of determination, my lord. The court says the relationship of the employer and employee between the parties. Firstly, the first party, whether the first party completed 240 days of the work in the preceding 12 calendar month from termination, whether the termination of the first party workman are against section 25 of the industrial, to what relief the first party workman is entitled. Thereafter, my lord, the statement of the witnesses were reproduced. That, my lord, I will read the deposition itself, but my lord, now my lord may kindly consider page 97, second line onwards. First point which the court was deciding whether there is any relationship of employer and employee. Now, my lord will find the finding at page 97, second line. It says this point is answered in favor of the first party and against the second party, first party employer and workman within the meaning of Industrial Dispute Act. So, my lord, this relationship of employer and employee, the court arrived to the finding that there is an employer-employee relation. Now, my lord, so far as the second point, whether the first party workman completed 240 days. Now, my lord, they have worked from a particular 2007 to 2019. That was not disputed by the other side. I will show, my lord, one document, their own reply at paragraph number 5, my lord. They have categorically stated they have worked from time to time under the executive engineer. They have categorically said. So, my lord, now, my lord, may kindly see the point number 2. The court says, pursue the evidence, this onus of proof is on the so and so. Now, my lord, the court straight away started relying judgments, my lord. Now, first judgment, the court relied, point number 1, my lord, may kindly see facts were not recorded, says the onus is on the workman, and thereafter this first judgment. Now, my lord, may kindly come to page 92, first judgment completed at para 1, second judgment. Thereafter, my lord, may kindly come to page 100. Now the court says, therefore, the first party is required to step into the witness box and adduce, page 100, my lord, and adduce cogent evidence, both oral and documentary. In this case, out of 41 who signed on authorization, so and so, only 3 persons were examined. PW1 has stated that he worked for 240 days every year in work from 2013 till 2019. He also stated that he has not served any notice or notice pay by the department and no reason was attributed for his termination. He marked his service certificate, exhibit 1. He stated they were again engaged after 1 year of COVID. No one was approaching for work, but then APWD people came and they were terminated. In the cross-examination, he stated that work continuously from 2013 without any break. PW1 is not clear. Now, my lord, can you see how the court considered? PW1 is not clear that on which date he was terminated. We have said in the month of June, we have terminated. From 1st July, my lord, we were terminated. It is there. On terminated or so and so. He did not state what manner he completed 240 days. Pausing for a minute, my lord, I worked for years together. The 240 days of in last preceding 12 calendar months starting from so and so, he may be mentioned to show continuous for benefit of so and so. The workman has to prove 240 days during the last preceding 12 calendar month. The workman has to prove the fact that placing cogent evidence. He may be mentioned that continuous service is not to be counted in the period of work, the precedent so and so as held in so and so. In the above decision, the Supreme Court. Thereafter, the Supreme Court judgment was referred. Relevant portion of the judgment. Now, my lord, again judgments. Now, my lord, we kindly come to 102, my lord. After the judgment, it says Rajesh Paul stated that he worked under the second party from 2011 to 2019. He marked his service certificate and he was terminated in July 2019 without any break or any order of termination. In cross, he stated that he had they had off days during Sunday and other holidays. However, no date of termination has been given by second. He doesn't state that how 240 days is constituted in the last preceding from the date of determination. Both so and so exhibited. These exhibits are general certificate with starting to whom it may be also written that this certificate has been issued for the purpose of applying job. Clear the certificate and not intended by the certificate for certifying continuous service. The wording of this is to certify that so and so has worked under so and so with effect from 2014 to 2019 as unskilled mandate and I have the experience. The certificate has been issued for the purpose of applying the job. From the bare reading it appear it is a certificate showing experience. It doesn't mean that on every day or specific day during the period. Yes, my lord, as if the labor code is acting on behalf of the respondent authorities, my lord. If my lord sees, same are working except the name of the employees admitted so and so. This certificate are general and doesn't prove particularly that so and so. PW3 stated that he worked in electricity department at Manglutan from 2016 to 19 as heavy vehicle driver and was terminated in 2019 for the reason they asked for wages of 1/30. He did not state about any particular date of retrenchment. He did not show how he completed 240 days working day during the so and so. Although in his cross exam stated that he worked for 240 days in a calendar year, but he did not specify. PW 1 to 3 could not prove the cogent evidence. They completed 240 days in last preceding 12 calendar month immediately before their termination. PW4 Rambala stated that he was the Gram Panchayat of Vandur Panchayat. He stated that JE Electricity used to employ workmen for the work of the department from the villager itself after taking their opinion. He stated the workman did not work under Manerga. PW Pradhan is another Pradhan who's another workman who stated he is still working as DRM in APWD. Now, this PW5 was an employee of APWD who was subsequently after our retrenchment was working. We examined him. He stated that now instead of these petitioners, they are working there. DW1 and 2 did not state anything regarding the number of days. My lord, the court was number of days. My lord, this concept of 240 is, my lord, they are working for years together. The concept of 240 days is that 25B says, if within a calendar year, a person complete 240 days, suppose I work for 8 months and I complete 240 days, then in that case, I am entitled to get the benefit of mandatory protection, my lord. Here it is not a case of 240 days or 260 days. Here it's a case where a person worked for years together. Now, my lord, even the Sunday and the holidays, my lord, that are included. It is not a person has to work on every day for the purpose of counting. American Express judgment 1986, my lord, Supreme Court had said so. Now, my lord, this court, as if this workman has to establish that 240 days, instead of year, we have to write that we have worked for 240 days. Now, my lord, can you see, DW1 and 2 did not state anything regarding the number of days. Workman for exhibit so and so, did not show that the first party workman worked for 240 days in the last preceding immediately from the date of retrenchment. Assume the decision relied on the first party, namely so and so. In this case, Honorable Supreme Court held that applicability of section so and so are not only applicable to the full-time employed, but also applicable to part-time who are under the control and supervision, and therefore the part-time workmen are also entitled to the benefit. In this case, the workmen are not the part-time employee. Thus, the decision is not applicable. not applicable, and this decision is not applicable. Another Xerox copy in WP number so and so is placed on record. Peruse this case, directed the authority to consider the representations. This case is also not. There is no finding. Point number 2, there is no finding. Point number 2 ends. Now point number 3 starts. Now point number 3, my lord, will find section 25F was quoted. Thereafter, my lord, Supreme Court judgments were quoted. No finding. Point number 3. No reasoning, no finding. 2 judgments were quoted. Section 25 was reproduced. No finding. So point number 2 and 3 was never concluded. Now, my lord, may kindly see point number 4. Therefore, the retrenchment is not unjustified.
Read the middle portion of this paragraph in 105, dissettled law.
My lord, it is.
Starts as held.
Yes, my lord. To be entitled, the workman has to prove that it worked for 240 days in the calendar month. As held in point number 2, the workman could not prove that immediately before and from the date of his, as held in point number 2, the workman could not prove his work in proceeding from the retrenchment. The first party workmen in this case are not entitled to. In between, my lord, I'm sorry, my lord. In between, it has said, I rely on the decision because, my lord, the judge was relying only on decisions, my lord. Now, my lord, may kindly see. Now, the concept of 240 days, my lord, there is no denial from the authority that we have not worked for the set period. They say that you are not my employer. The court said they are your employer. No, my lord, may kindly see. Two paragraphs just I am placing, my lord. And thereafter I will come to the evidence also, my lord. My lord, may kindly come to page 28, my lord. I will come to the judgment, my lord, page 28.
So paragraph point number 4 at page 105, we finish it up and then go back to 28.
Yes, my lord. It says that therefore the retrenchment workman is not unjustified or illegal or does not hit section 25. The statement of claim is devoid of merit and dismissed.
All right.
Now, my lord, my respectful submission is that 240 is not a magical word that we have to say everywhere that 240 days, 240 days. We have categorically said that we have worked from 2007 to 2019. My lord, may kindly see page 28 once, paragraph number 5 of the claim petition.
Yes.
My lord, we have said the first party workmen were continuously working under the second party employer from 2007 to 2019.
How did you get your pay?
Pay directly in my bank account.
The period of days?
Days, my lord, they prepare the bill. I will show evidence of the junior engineer. He prepares the bill. Now, my lord, I just show this para 14 of their reply at page 50 against my para 5.
Page 50.
Page 50, my lord, this is the reply to my para 5.
Yes.
They say with reference to the averment made in para 5 of the same are denied and disputed and the first party are put to strict proof thereof. It is to further submit that as on date no daily rated mazdoors are exist in the electricity department. It is further submit that the first parties were engaged from time to time by different division of the electricity department in Andaman Nicobar Island for maintaining power, generation, transmission and distribution system network or other emergency work through the tribal council or through the Gram Panchayat, and the second party has never engaged the first party directly for execution of any work. No, they are accepting and admitting that we have worked directly under them. They say that we have not engaged you. You have worked under our direct supervision. And they say that after our disengagement, they have not engaged any other daily rated employee. So they are accepting our engagement under them, under their supervision. We have discharged the duties which are perennial in nature. It is not a seasonal work. It was perennial in nature. Now, my lord, may kindly come to the depositions, my lord. Page number 74 onwards, my lord. And after we are seeking only reinstatement. We are not seeking regularization. Page 74, my lord.
Yes.
This is PW1. He stated, I used to work in electricity department in Manglutan site office from 2013 to 2019. I used to work, July 2019, my lord. I used to work in the same manner which was done by the regular Mazdoor. I have worked for 240 days every year. I was not served any notice or notice pay by the department. No reason was attributed for my termination. This is my service certificate, where I was asked to go to electricity where we engage as DRM. Our department used to pay as wages and the amount was credited in our account. Decision or order circular of the administration by which it is stated that though workman can be terminated is marked as X for identification. We were again engaged for 1 year when during COVID-19 time, no one was approaching for work. But then again, when the PWD people came, we were again terminated. When we were terminated at that time, 270% inducted from PWD. And again, we were inducted when those PWD workers were not coming. But again, we were terminated when this period, these PWD persons joined after COVID. The persons who were inducted were even with lesser experience by 1 or 2 years than me. They were also inducted as DRM. But after termination in 2019, when this conciliation proceeding was going on, and when the pandemic of corona was there, nobody was going to work. They called these persons, they extracted their service. When admittedly the conciliation was pending, they said that you are not our worker. Now, my lord, I pray for instance. No, my lord, may kindly see the cross-examination. We were given order of appointment by the department. This is the certificate by assistant engineer. Our salaries were paid directly in our bank account from the electricity department. I have placed on record such bank account to show that salary was credited from the electricity department in our account. I worked continuously from 2013 without any break. I have attendance report. We were paid on monthly basis. I have the bank details and the letter by elected to the Pradhan that they require the workman. No, there is a suggestion that at no point of time you have completed 240 days. When there is a specific statement made in the chief, my lord, that I have worked for more than 240 days. Now, my lord, PW2. He says, my lord, I worked at Manglutan site office, my lord, page 76. I worked at Manglutan site office of electricity department. This is the certificate issued by so-and-so. Towards my service, I worked continuously. I was terminated in July. No order was issued at the time of termination. We applied our pay to the extent of 1/30th. Therefore, the department terminated our job in 2019. From 2011, we worked 2019. Therefore, we were terminated in our service. Plus, junior persons were inducted from PW. I pray that no order used to be given for we had day during Sunday and holidays. JE sir used to take work from us continuously. Department used to pay our wages. Volunteer JE sir used to make the attendance and send the payment. We did not get any order that for what reason we were terminated. It is only JE sir asked not to come from tomorrow. As far as we know, department paid our wages. Now, here also there is no suggestion that you have not completed 240 days. Now, third witness, he said that page 77 minute. I worked in electricity department from 2016 to 2019 as heavy vehicle driver. I was paid wages for the Mazdoor only. I was terminated in the year 2019. We asked for wages of 1/30th and thereafter we were terminated without reason. After termination, persons from PWD were engaged in our work who have lesser experience than us. No notice or notice pay was served before termination. Electricity department used to pay our wages through bank. We were paid 480. I pray that I may be answered. I worked from 2016. We were asked to come for work and then asked whether I have license and thereafter I was employed as driver. There is no written order to this effect. I used to work for 240 days in a calendar year. This question might have been put to him and he has said that we have worked for 240 days in a year. I have no document to show that electricity department paid the wages except the bank document. Now, my lord, after this, the pradhans were examined, my lord. PW4 is the pradhan of one panchayat. He say, my lord, page 78. He say that I am a former pradhan. Vandoor Gram Panchayat has only one site office. The JE of electricity used to employ workmen for the work of department from the village itself after taking our opinion. They use us to send such person for work if I have any and those person used to work for the electricity department. When we sent them and the payment was also made by the electricity, they did not do any work of Manrega. Panchayat never made any payment to them. Specific answer, my lord. No, my lord, he was cross-examined, my lord. I am sorry, it is handwritten, my lord. My lord, original case record is also there, my lord, I think. It says, my lord, electricity department asked for DRM from me verbally. Second, my lord, yes, there are 3 letters by electricity department for mandate, but from our panchayat, the documents are marked so and so. Not a fact that the department never thereafter suggestions, my lord. Now the dispute is that they say that the panchayat said that you have engaged them. You have asked us, we have given the name that these persons can work. Now, my lord, one more Pradhan was examined, my lord. It says, my lord, I used to send people to electricity department. It's 80, my lord. Electricity department and ask for me for DRMs. Attendance and payment of wages were made by electricity department itself. Payment never paid to them. Thereafter, my lord, he was cross-examined. He said no document was produced and suggestion was put. Thereafter, my lord, we at page 81, we have examined one DRM, my lord, because our case is that I ought to be the last person in this head cadre. The moment you engage another person, my lord, then it is violation to section 25 GNM. Now, my lord, page 81 to prove that, though they admitted that. They admitted that in the judgment also it was recorded that they say that after that they have engaged the DRM from APWD. Here he say, I am still working as DRM by APWD. I work at DRM from so and so in between outsource as a mandate. Again, PWD took us as DRM. We are getting 1/30th. This is the Xerox copy of the memorandum, my lord, whereby he has got 1/30th. The order APWD so and so paid one. I know that vacant post by electricity department. It is correct that the working with the APWD after returning back from getting 1/30th DRM High Court order so and so. Now, my lord, he said that we work there in electricity department. I know that that there is vacant post in electricity department. Thereafter, my lord, they examined 2 witnesses. Page 82. He says that I was working as assistant engineer in electricity department. So and so within the territory. So and so. This is the certificate copy of issued from my office to the Pradhan Gram Panchayat asking him to provide 125 mandate. This is the certified by me. This is my signature. This is the copy raised by the Pradhan. This is the so and so. The bill was, now let me kindly have a note of this. The bill has been verified by the junior engineer of my office on the back side. This is another order of procurement 100 made by for the Pradhan by attesting me. This is my signature. This is the document so and so. Against the this order, only this bill dated has been raised by the Pradhan to the department. The bill, the junior engineer has verified the bill on the backside. The copy of the order dated issued by the assistant engineer of the Pradhan required 100 mandate. The order is attested by me. This is the signature. So and so, my lord, different bills were exhibited by him, my lord. Different bills were exhibited by him. Where is the countersign is verified by the junior engineer. Now, my lord, may kindly see the cross-examination. I am working in electricity department since 1987. I was posted at Fararganj since September 2015. It is correct that I submitted document till 2015. Without verifying at this stage, I cannot state whether the workmen in this case are workmen in our department till 2019. It is correct that we had on Manogar pattern as reflected in the order, we paid them the wages which were decided by our department. I do not know whether the person engaged in Manrega does not get the minimum wages. There are 11 panchayat in our area. We used to take from all panchayat. I only submit the paper to Pradhan Manargad, not of other Gram Panchayat. These are my signature. Thereafter, suggestions were given. Not a fact that my department and Pradhan conspired and collided together to take the person and illegally took work. Not a fact that we misappropriate the wages of the standard mandate by colluded when after joining my duties in 2015, the workers in general used to get direct payment from the department. Now, my lord, the junior engineer under whom they have worked, he was examined, page 85. Presently, I am posted at Manglutan site office as junior engineer. Electricity Vandur Panchayat comes under the site office. Sri Ram Bala was the Pradhan of the Panchayat from 2015 to 2020. I was working as junior engineer in the office from 2015 to 2020. The approval which used to come from administration for employing through Pradhan was for mandate and not for DRM. During 2015 to 2020, I did not take any mandate from Vandur Panchayat, neither in writing nor verbally. I know the difference between mandate and DRM. Not a fact that the DRM mandate are same. Mandate means the estimation of the people required to do any specific job. I do not know whether this same procedure is followed in all departments. I know the 2% present in court who worked in our concerned department as mandate during 2015 to 2019. Perhaps in 2019, their employment were stopped. The persons who came from APWD for work in place of this person were DRM from APWD. It is fact that people who came from APWD as DRM were junior to these employees as mandate. We do not give any notice or notices paid to the at the time of termination of this. When I know the DRM employed through AM were paid 1/30. I do not know whether the APWD also takes the 4 DRM as mandate. It is fact that DRM from APWD do the same work. Mandate. No, my lord, he has accepted everything. That similar nature of work after them, this DRMs were engaged, that they were terminated in July 2019. That also he has said, my lord. So these all are admitted fact, my lord. Now, therefore, my lord, on the basis of the evidence which was led before the trial court, the petitioners able to demonstrate that they have worked for 240 days, and my lord, the protection which is there under the Industrial Dispute Act, the mandatory requirement, that was not followed. And therefore, we are entitled for reinstatement. Now, my lord, may kindly see first section 25B, my lord.
Why don't you take your seat? Alphabetically suddenly. এই বইটা কিন্তু এদিক থেকে এদিক দিয়ে মোটা 5 নম্বর বই এদিক থেকে মোটাটা সরান সরান ওইটা দিন yes
My lord, section 25B, my lord.
yes
My lord, it says definition of continuous service. For the purpose of this chapter, a workman shall be said to be in continuous service for a period if he is for that period in uninterrupted service, including service which may be interrupted on account of sickness or authorized leave, or an accident or a strike which is not illegal, or a lockdown or a cessation of work which is not due to any fault on the part of the workman. Where a workman is not in continuous service within the meaning of clause 1 for a period of 1 year, 6 months, he shall be deemed to be in continuous service under an employer for a period of 1 year if the workman during the period of 2 or calendar month preceding the date with reference to which calculation is to be made has actually worked under the employer for not less than Roman 2 is applicable in our case because Roman 1 is applicable with regard to mine, the workers who are working in mine. 240 days in other case. So this is applicable. So my lord, the calculation is if within a year a person complete 240 days. Now my lord, once this condition is complied, now my lord may kindly come to section 25F. It says, my lord, condition precedent to retrenchment of workman. No workman employed in any industry who has been continuous service for not less than 1 year under an employer shall be retrenched by that employer until the workman has been given 1 month's notice in writing, indicating the reason for retrenchment, and the period of notice has expired. The workman has been paid in lieu of such notice. Wages for the period of the notice. The workman has been paid at that time of retrenchment compensation, which shall be equivalent to 15 days average pay every completed year or continuous service or any part thereof in excess of 6 months. Notice in the prescribed manner is served on the appropriate government. So this is the condition precedent, section 25F. Now, my lord, since I completed 240 days, they have not followed this. So there is a mandatory violation on their part, which gives a right for reinstatement of these petitioners. Now, my lord may kindly come to section 25G. Procedure for retrenchment.
Yes.
25G, my lord. It says procedure for retrenchment, where any workman in an industry established as a citizen of India is to be retrenched and he belongs to a particular category of workmen in that establishment, in the absence of any agreement between the employer and the workman in this behalf, the employer shall ordinarily retrench the workman who was the last person to be employed in that category, unless for reasons to be recorded, the employer retrench any other workman. So once I have been retrenched from the said service, I have to be the last person in the said cadre. No fresh engagement could be made.
But then where is the particular category of workmen?
No, particular category means we are the delegated employee who work.
Delegated
No, they engage the DRMs from OPW for the same nature of work. They themselves says, BWP himself says, same nature of job. So the nature of job is a category, my lord. So, my lord, they have violated these mandatory provisions and the London Labour Court has not considered it. No, my lord, there is an argument that it was mandate and all. My lord, nomenclature will not make any difference, my lord. In Jagjit Singh case, paragraph number 55, categorically stated, casual, mandate, this DRMs, this all, you have to see the, my lord, I will place that. It's a bulky judgment, my lord, I will give. Para 55, my lord, I will give that judgment. Now, my lord, this is a beneficiary legislature, my lord. Now, these workmen's maybe not in so many words, my lord, but they are able to demonstrate before the court that they have worked for more than 240 years. And protection is warranted since they have not the mandate of the law. So therefore, my lord has to consider it, my lord. This is absolutely patent illegality, despite of having evidence on record. The court has pursued and passed this order, my lord.
My lord,
1 minute, will you not place those judgments that you are relying upon? Then I'll start with him.
My lord, I will just hand over the copy that Jagjit Singh paragraph.
The portions that you are relying upon, you must be having soft copies, please check.
Jagjit Singh, because I may be having, and that American Express, that my lord, that judgment I will place that 240 days doesn't mean.
No, then after he starts, you can.
I will just hand over the copy. I will not.
No, you need to place it. Only handing over will not do.
My lord. My lord, those judgments are not required, but Jagjit Singh only I will place for that preposition.
Whatever, it is up to you to rely upon the decisions that you choose.
Only my lord, Jagjit Singh I will place, my lord. Rest judgments are not required in this case since we have worked for more than 240 days.
Yes.
my lord,
Under the Industrial Disputes Act, my lord, there is no appeal provided against the order of the labor court. But the labor court is the original court, and my lord, the scope of interference in a writ petition, my lord, filed by the petitioner is extremely limited, because my lord, this is not a 226, my lord, in the sense that, my lord, unless it is brought within some extreme situations, like if there are no reasons at all, or if natural justice is not followed, or if it is patently arbitrary, it is only in those circumstances, my lord, that this honorable court would ordinarily interfere with an order passed by the labor court, my lord. Ex facie, my lord, the order passed by the labor court, it considers the arguments made by both the parties. It has been passed after hearing both the parties. Judgments have been referred to. Evidence has been appreciated. Now, mainly because, my lord, what the effort of the petitioner is to convince or to persuade this honorable court to take a different view, appreciating the evidence, which, my lord, is, in my humble submission, is not within the ambit of a writ petition challenging a labor court's order.
So, but then where will he go? He cannot be non-suited.
This is a very, my lord, because this is, I can produce those judgments also. Ordinarily, my lord, court would not interfere when it is well reasoned, my lord, because there are so many cases, my lord, where orders of labor court are not interfered with, because, my lord, there is nothing arbitrary per se on the finding for the labor court.
But then the court has to apply its mind to come to a finding that yes, whatever the reasoning the labor court has given is proper.
My lord, my humble submission is this: will arrive, will look at the material to arrive at a conclusion as to whether the decision of the labor court is arbitrary or it is implausible completely. Not to see whether the decision of the labor court is correct, because, my lord, that would be the ambit of an appeal. This is not an appeal, man, it's a writ petition, actually.
Yes, but then where there is no appellate provision.
That means the law does not intend that there should be, they can file a special leave petition in the Supreme Court in that case. The SLP can be filed against all of us. Now, my lord, my second point is, my lord, even the judgment that they are seeking to rely upon on the law, even otherwise is well settled, my lord, that the onus or the burden of proof is always on the workman who approaches the labor court. There is no reverse burden of proof. So, my lord, merely saying that because, my lord, the defense, my learned senior has read all the documents. The defense of the employer was that they are not employed under us. They have been employed from time to time through third parties. They are not our employees. They are not workmen within the meaning of the Industrial Disputes Act. It was not, so therefore for them, the onus is on them to establish that they have worked for 240 days in the last preceding year. So, my lord, that is the mandatory requirement of the law. So they cannot do it in reverse to say that where we have said that we have worked continuously. In response, the department has said that no, you are not employed under us, you are employed from time to time. That doesn't mean there is an admission that they have worked for 240 days. So it is for them to lead evidence to prove that, my lord, they have worked for 240 days. Now, my lord, from the reading, even if we were to look at, and the labor court has looked at the evidence threadbare and has arrived at, my lord, I can say from my limited experience, my lord, my lords, usually, my lord, labor court orders, I've seen, my lord, this is extremely well reasoned, my lord, and detailed reasons have been given, my lord, evidence has been appreciated. It's not merely that only judgments have been cited. The labor court has arrived at a conclusion that you have not laid evidence to prove that you have worked for 240 days. As it has in fact followed from your lordship, what is the manner in which the payments have been made? So, my lords, it would be very simply, my lord, they could have produced the bank statements to show that we have been paid for 240 days in the last preceding year. Where is that evidence, my lords? They have barely stated that we have that it can be.
How much did you pay? How much did you pay them? And what is the calculation on the period?
Them, my lord. They are
you must be having records. You are the employer. They worked under you. Where are those documents? Please show me.
No, that is exactly the point, my lord. Those documents have not been produced by.
You must be having those documents.
Record is before your lordship.
Possibly those documents were not there.
Then they, my lord, that on that ground itself, my lord, their claim is my humble submission should be rejected, my lord, because the law puts the burden on them, my lord, to prove that they have worked. Our stand that the labor court says you have not.
But the court wants to see how much you've paid them and for how many days.
That, my lord, I have to produce, my lord. I have to come back after.
Where are the banking bank passbooks to show how much you have
My lord,
received.
some are exhibited, my lord, some of
Some
them.
are exhibited.
Yeah, because I,
The figures are mentioned, 21,000, 24,000 in one of the evidences of the junior
lord.
officers.
my lord,
The junior engineer you read out,
yes,
the figure was there.
yes, my lord. The figure was there, even the minimum wages is also there, 480
But then
rupees.
what is the payment?
They have paid on monthly basis, my lord.
That also is there in the evidence, but
Yes.
I need to see the figures and the days, number of days.
My lord. My
So
lord,
from
the
this-
lower court record is there, my lord, if I, Manoj,
Let me see.
lower court record. इतना ही है. No.
You have to inspect and find it out.
My lord, it is there because from evidence it reflects that bank
Those were
statements.
placed. The how were the exhibits marked?
Who exhibits were marked?
Yes.
Evidence, maybe. Evidence.
Junior engineers evidence deposition you read out.
Yes, my lord. That is at page number 82, 84, I think. That statement is in assistant engineer statement is there, my lord, at page 82.
Yes, page 82, 24,100.
Yes.
Pradhan. Now this 24,100 is meant for how many people? For how many days? The man days, how many?
My lord.
What duration also, my lord?
No, we have
Certainly
said
the
the monthly payment was made, my lord. We have said so,
Yes, monthly payment for how many people?
my lord.
30,125. Exhibit B1, C1.
Yeah, right. Documents which we are seeing, several of them have like 100 days, 20 days like that.
They were receiving monthly salary, my lord.
How much is the figure
Yes, that
per head?
because, my lord, in evidence I have read, my lord, 480 rupees per day. I will just show from the evidence.
Show it. Figure.
480 rupees per day,
480.
my lord. In evidence I have read somewhere, my lord, 480 days.
If it is 1 by 30th, what will be the figure?
Oh, 1 by 30th, the figure would be at that point of time at least 23 to 24,000 per month. Now it is more than near about 30 now.
That time it was 24.
At least 23, 24, my lord.
And you say they received 480 rupees.
My lord, page 77, my lord. The deposition of perhaps PW3, my lord. He has specifically said we were paid rupees 80 per day as per administration rate. That is the minimum wages.
77.
77 PW3 perhaps, my lord. Yes, PW3. In his chief last line, my lord, first paragraph.
480 rupees per day.
Per day as per administration rate, that is the minimum wages at that point of time.
By not seeing the record, even the beds or what we are seeing. Kindly see this record.
This used
Yes.
to send such person forward. And used to work for the listener when listen.
85 and 89 to 100. They were mainly engaged for very small duration, sometimes for 100 days. Maximum was 200 days, 240 days never. 83 to 85, kindly see my lord, 89 to 100 and 101. to 85,
We will again engage after
89 to 101 days.
480 rupees per day
per day.
into 240 days. Make the calculation and show me that they received this amount in their bank account.
Yes, my lord. I will show monthly receipt, my lord. Monthly.
If it is monthly, yearly,
From 2014 onwards, my lord, it is.
yearly
Yes.
you calculate
Yes.
and show me that this is the figure. that they received,
my lord,
which will go to show that they have worked 240 days.
my lord,
Otherwise, you are out.
my lord, my lord,
Do you follow?
My lord, my lord.
Because this is your consistent stand
my
that
lord,
your clients worked for 240 days
my lord,
in each year,
my lord.
minimum. So they
Minimum.
must have been paid for
Yes,
240 days.
yes, my lord,
Show me that they received 240 days.
my lord,
And 480 rupees, they admit they got per day.
my lord, my lord.
So 240 into 480
My lord, in a year,
in a year.
my lord.
Same source.
Obviously from the same source.
Not
from
same source.
different-
No.
No, they worked in one place. They do
Yes.
not have so many employers that they will be given work
No,
on regular
I guess
basis.
They would have several employees.
No, they
No,
take
no, how it can be?
TRMs.
Now the same, sometimes the same man.
TRMs, mandates,
So,
right?
Kindly see, my lord, page 83 to 85, 89. to
Let me produce that, my lord.
It was very clear, my lord, how many days there. This is the evidence on record.
This is some.
150, you
150
show
days. Then my lord will see.
150 mandates.
Yeah.
Maybe for one, it's 150. And then for the other,
No,
it's 75
they are employed
something.
as a group, so my lord, the employer, not the employer, the respondent was writing to say the Gram Panchayat. Or they were.
Provide me so
provide
many
for 100 days.
100 mandates.
That's how these people were employed.
No,
So it will be evident for none of the, at least so far as the evidence on record, it is never for more than 240.
240 days.
No, my lord, this is not their case at all. Yes,
Don't go into all these things. Show me.
my lord,
It is up to you to show
my
that
lord,
you received
my lord,
payment for 240 days
my lord,
in every year
my lord,
from the same source
my lord.
by
My
this
lord.
electrical department. Or-
More particularly the last period, my lord, that before retrenchment.
Yes,
The other aspect, my lord, is that assuming that they are able to produce some, the evidence has to be appreciated, my lord, by the labor court. In that case, my lord, the matter has to go back to the, not
Let them
anything
show-
on that either.
let
No,
them
I-
show at
explain
least
why-
that they
Yes,
have
yes, of course,
something.
of course.
If they cannot show, then it
Of course,
goes.
no, I am submitting something different. Now, the fact is, my lord, assuming, let me assume everything in their favor. That they are able to satisfy this honorable court, that they have worked for 240 days. So that is the highest that will be there if they succeed. Now, even in that case, reinstatement is not an automatic consequence. In that situation, my lord, now there are several judgments, my lord, that especially in the nature, this kind of work, my lord, reinstatement does not naturally follow. There will, maybe it will be compensation, it will, because eventually what is their grievance? Their grievance is they were not given notice. So that it doesn't follow because the court will.
Let us see, let us see first. These are all consequent. If he cannot show that he has not worked, then all submissions will fall flat. The nomenclature
lord.
and anything.
My lord,
Please come.
let it be on Monday, my lord, so that I can collect. Only thing, my lord, after 2014 or 15, my lord, this transfer was made in the bank. From evidence it reflect. I will produce
Because according to your submission, you were there till 2019.
2019, my lord.
July
2019.
2019.
July 2019, they were retrenched.
Show me. Her detailed submissions made on behalf of the petitioner. Yeah. The learned advocate representing the respondent authority commences argument but does not conclude the same stuff. The learned advocate for the petitioner is directed to produce evidence in support of the submission that the workmen performed their work continuously for a period of 240 days in a year prior to their retrenchment.
My lord.
List on, if you want, I can keep it on the 10th also.
10th, my lord,
Tuesday.
because there are several persons.
Tuesday.
Yes.
Item number 23, WPA 177 of 2022.
For the private respondent, my senior peers. It's in his full writ petition only.
Seek adjournment?
They are not adjourned. Deputy Commissioner was directed.
Whether the RC case particular to that proceeding was available, because the Calcutta has already submitted report saying that 2001 that RC case is not available. And the report is also arrived, not account. I can give accounts copy to them.
Yes.
Sorry, I will file. That's not the case.
It will be on Monday, my lord.
Monday.
My lord, in such scenario, actually, we are not sure about my seniors' availability next week.
So
Uh,
then it will go on.
Awaiting their report.
Very well. Let the copy of the report be, let advance copy of the report be served upon the learned advocate representing the petitioner and the private respondents. How many of them? One respondent. Stop. Next. It will be open for the petitioner and the private respondents to file exception to the said report. Stop list in the next circuit. When will you file the original leave granted to the learned advocate representing the deputy commissioner to file the to file the report by the deputy commissioner in the department in the course of this week?
Number 34, WPA 150 of 2022.
My lord, this one just not today, because today I have mentioned 4 matters, my lord. These
Yes,
5 matters are similar, my lord. more or
very
less.
well. Adjourn for this week on the prayer of the learned advocate for the petitioner. 25 also same,
No, my lord.
separate. Yes,
Number 25, WPA 220 of 2022.
My lord, this is the second round of litigation. My lord, this petitioner worked
FCI.
under the FCI, my lord, for several years, my lord. That is on and from 1998 to 30th of April 2011, my lord.
Yes,
Now, my lord, after his termination, because he worked for more or less 13 years under the respondent authorities, and thereafter one fine day he was terminated, my lord. Thereafter he filed cancellation, and ultimately the matter came before the labor court. And in the labor court, my lord, on the first occasion an award was passed whereby certain documents were not taken into account. And on the said score, the award was set aside by this honorable court and the matter was remanded back before the trial court. Now, my lord, after the matter was remanded back, now once again an order was passed. Award was passed, page 81.
yes.
My lord,
Is this under challenge?
yes, my lord.
Alright.
Now, my lord, here if my lord sees, this award is of 4th of May 2022. Now, my lord, the reference is whether the service of so and so, the workman need to be regularized by the management of Food Corporation of India, Port Blair, and whether the action of the management of the Food Corporation in terminating the service of Sri so and so, the workman with effect from May 2011 is legal and justified. While order dated 1st February 2019, this labor court answered the reference and held that the action of management of so and so is legal and justified. It is also held that the first party workman is not entitled for any relief.
Anyway, don't read all
My
the
lord.
things, come to the
No, my lord.
operating.
No, only one thing, my lord. My lord, may kindly see page 82, paragraph number 3, my lord. In this case, got it, my lord. The first party filed a petition on informing the first party challenged the above award, and honorable court set aside and remand back the matter after taking into consideration the letter dated 21st of April 2009. Now, my lord, kindly see, my lord, the case of the workman, my lord. The first party workman filed its statement of claim on 12th of January 2013, stated that appointed as daily rated driver under the second party on 1st December 1998. And since then, till the month of April 2011, the first party was working with the second party as driver. It stated that all of a sudden from the month of May 2011, the district manager, FCI, without giving any notice or any order, did not allow the first party to do any job and retrench first party from the service without following the process of law. It stated that the first party made several representations, so and so. So, my lord, this speaks about the retrenchment, my lord. Now, my lord, the stand of the second party. The second party submit that the first party was never appointed by the second party, nor he worked continuously as required for regularization of workmen. It is submitted that the first party worker worked on need basis with considerable gap, and the payment was made out of contingent fund and not from regular fund maintained to pay salary. It states that the first party workman was a daily rated worker on temporary employment or gets engaged as a contractual or as casual worker, which is not based on any proper selection as recognized by the relevant rules or procedure, and the first party is aware that the appointment is temporary, casual or contractual and cannot be legitimate expect for being confirmed without following the due process of law. It states that the area manager is not the competent authority for recommendation of the case of daily rated worker. It is denied that the recommendation was made keeping in view of the length of service. Second party denied for issuance of certificate and stated that the certificate is only with respect to the driving license of the first party. Thereafter, my lord, evidence. PW1 so and so was examined. He marked exhibit 1 to exhibit 17, my lord. He was cross-examined in full. First party examined one Ishwar Singh, manager cargo, in charge port management board. He proved 14 vehicle entry pass. PW2 was cross-examined by the second party. Second party examined DW1 so and so. Point for determination. Whether the first party workman completed 240 days of work. Second, whether the termination is illegal. Third, whether the workman is entitled for regulation and what relief he is entitled. Now, thereafter, my lord, as usual, the labor court first cited certain judgments. Thereafter, my lord, thereafter, at page 86, second judgment, last paragraph. Now, my lord, page 88 is the third judgment. The court says the onus of proving such for 240 days is on the workman, and thereafter rely upon the third judgment. Thereafter, my lord, another judgment at page 89, second paragraph. Thereafter, my lord, page 90, first paragraph, another judgment, my lord. Page, thereafter, next paragraph, another judgment, my lord. Next paragraph, another judgment, my lord.
Now 91.
Now 91, my lord. Now, yes, my lord. It says, now, my lord, the Supreme Court and our court has deprecated this practice, my lord. Now we may proceed to find out whether the workman has proved that it worked for 240 days in the last preceding 12 calendar month from in the claim petition. First party workman stated that he was appointed as daily rated driver under second party and worked since then till the date of so and so. He stated all of a sudden from the month of May, the second party retrenched his service. He didn't state any specific date of such retrenchment. Pursued the evidence of the chief of first party, he stated that in the way the so and so, he further stated that he worked for 14 years to the fullest satisfaction of the higher authority of the second party as driver. He didn't state any specific date of May 2011. But same presiding officer, same presiding officer, the other case. He didn't state specific date of May 2011 for his treatment in his affidavit in office and pursuit his crossing. Nothing about his specific date of retrenchment from record as so and so. He worked till so and so. He was retrenched in the month of I take the first party workman so and so. The first party workman expressly never said either in his affidavit in chief or in his statement of demand that he worked for 240 days in a calendar year, at least in 12 calendar month preceding to the date of retrenchment. Exhibit 1 is certificate of second party data. It reveals that the first party worked as jeep driver under with second party for the last 2 years. However, this document doesn't state that the first party worked.
Here also it's the same thing. You show me that you received the payment.
Here, my lord, there are several documents which were, first, my lord, he was a driver And for the purpose, he, along with his officer, used to go to port management board. Several documents were, gate pass were exhibited where the name of the driver is there and the vehicle.
240 days in a year?
My lord, for 240 days, my lord, at that point of time, salary was paid in cash, my lord, 2008. After,
Any signature that he accepted
my lord,
money in cash?
several documents are there, my lord. I can just show those. 17 exhibits were made.
Yes.
And one letter is there. That letter with the writ code, with the writ code asked them to take into account, because in that letter it was specifically stated he worked for a specific period, my lord. That letter is there, my lord.
We have denied.
My lord, may kindly come to page 42A. 42A. 42 is the letter.
21st of April 2000.
Yes, my lord. It's a typed copy, my lord. 42 is the original.
42 is the original.
And typed copy is at page 42A.
Was the signature proved?
No.
No, that signature was not proved, my lord.
None?
That officer, that the document was proved, my lord. That was exhibited, my lord.
Till the signature is proved and the
Contents are not
certifier will say
I
that,
got-
yes, this is my certificate, then how can you rely upon this document?
My lord, this was issued in the official course of business by the respondent authorities.
And this evidence ought to have been taken.
My lord, my lord, maybe
This
that
person, K. Satyanarayan, area manager, ought to have been.
he was, by that time he was transferred, my lord, and whatever, my lord, that was not done. But my lord, may kindly see the contents, because the High Court has said, no, my lord, no, one more thing, my lord. After the order of the writ court, whereby the writ court had said the labor court to consider it. No, my lord, this order was passed in the present, they are not challenged, my lord. It reached finality. No, my lord, inter-party binding. Inter-party binding, this,
Assuming it is binding,
my lord.
you have to prove that this letter existed.
My lord, in that case, my lord, then once again, my lord, then it's a difficulty. No, my lord, may kindly see the contents of the letter, my lord.
I can see that he worked for more than 10 years. This is the certificate that has been given. But more than 10 years, suppose you work for 200 days in a year.
My lord,
Or maybe 239 days.
my lord.
But the figure is 214 each year.
No, this is, my lord, continuous service, my lord, to 10 years, my lord. It is not that.
I take it. But then, since there is a denial that this letter was never issued, so it was the responsibility of the workman to produce evidence.
My lord.
If there is no evidence,
My lord.
what remains? Nothing doing. This cannot be helped. Please
No, my
come.
lord, in that case, my lord, let it be remand back, my lord, because it is a document. Now, in that case, my lord, in that case, there are other documents where from it clearly reflects that he has worked, my lord. Apart from this, because several.
This is the document relying upon which your matter was referred back.
My lord, my lord.
The
Apart from that, my lord, there is a document.
that
No, my lord, in that case, my lord, my submission may be recorded, my lord. What I am on, this document was exhibited. It is not that it was never exhibited. This document was exhibited. The London Trial Court, that the Labour Court, has not considered this document. I approached this court by filing a writ petition challenging the award. Now, this court, knowing fully well that it is an exhibited document, this court remanded back and asked the court consider this document. It is not the validity of the document, because already it is an exhibited document. The court said you consider and pass in judgment in the light of this document.
show me any finding with regard to this.
My lord.
Page 69. Page 69 of the repetition.
Page 69.
But the judgment starts from page 81.
Yes, judgment starts from page 81. No. Labor code.
The labor code
Labor
statute.
code.
Yes. How this 21st. Yes.
Similar manner, we have seen that the other certificate have been dealt with, my lord. Now, my lord, may kindly come to page 95, second paragraph.
The contents of the letter is reproduced.
Yes. From the letter, it appears that it is written by the area to the executive where requested to consider representation for offer of appointment for the post of so-and-so and for necessary action. In this letter, area manager now is working in this office as daily rated since more than 10 years in this office, so-and-so. This letter is dated so-and-so as per the Supreme Court in the precedent decision. First party required to prove 240 days of working from so-and-so. And this letter is of 2009, is of no help. My lord, can you see, my lord? How it can be? Moreover, for taking this letter as admission against it has to be unambiguous, unequivocal, clear. The letter doesn't indicate that how workmen work for 240 days. It appears to be a recommendation by the area manager to the superior of FCI to take action, to take case of first party favorably for his long association with FCI. It doesn't prove the technical term of continuous service in as much as working of 240 days. First, my lord, the first finding of the court in this letter is that since he was terminated in 2011, therefore this letter is of no consequence. Now, my lord, a person worked for more than a decade under an authority, and one fine day when he was terminated, and there is a letter issued by a competent authority saying that he worked for more than 10 years under the authority. Now, my lord, we have annexed several documents which were exhibited before the trial court, wherefrom it proves that my lord may kindly see his evidence that documents. No, my lord, here I say that, my lord, that London trial court went wrong, my lord. The London trial court has to decide the merits of the said letter, my lord. Now, my lord, may kindly see several documents were exhibited, my lord. My lord,
See, had you shown me any proof that you received the salary
my lord, yes,
40 days?
that documents are also there. Page 39, my lord, may kindly come.
Yes.
Page 39. For some period, he has filed it, my lord. My lord, he worked for 11 years. It is not possible to file all the.
Some period will not do. The year preceding is important.
No, no, absolutely correct. Absolutely correct, my lord. Absolutely correct.
So page 39.
39, my lord, in cross-examination,
Yes.
in a further examination, I am filing quite a number of documents today. These are the Xerox copy of the document. These are document marked with objection being certificate dated issued by so-and-so, copy of the receipt whereby the first party paid payment from so-and-so, copy of the letter dated issued by the
See the date 21st October.
to 31st October for a month, my lord.
Yes.
Yes.
Now 240 days.
My lord, now my lord, may kindly see thereafter.
And there is a gap.
Copy of the receipt showing that he has worked and received payment. My lord, for different period, he has submitted, my lord.
1st of December till 31st.
31st December. This is one receipt, my lord. Thereafter, copy of the receipt. My lord, what he has done, for every he has filed one receipt. He might have been advised likewise. He has, my lord, because he has worked for years together, whatever may be the advice, my lord, on the basis of that, if my lord sees for year-wise, he has submitted one.
But then one will not do.
I can produce it, my lord. I have it.
From 1st of January 2010, 11th of March 2011.
That is logbook, my lord. That is logbook.
Log.
Yes.
With respect to the vehicle.
And thereafter, my lord, this is with regard to the entry in Port Management Board. And the witness from Port Management Board was also examined. My lord will find that he also.
What is important is 240 days in the year preceding.
My lord. But what he has done, my lord, every year 1 month certificate he has filed.
How can it be rectified at this stage?
Only appreciate this situation, my lord. A person has worked for 11 years. So, my lord may kindly appreciate this situation. He worked for years together. Whatever may be advised, on the basis of such advice, he has filed receipt of every month to prove that he worked continuously of every successive year. That is what he has done in this case.
1 month in every year.
Every year he has done.
This is not the way.
No, this might not be way, but my lord, kindly appreciate the situation, my lord. This was.
I'll give you one opportunity. You show that you work for.
Yes, my lord. That definitely we can do. Yes, my lord. My lord. Only salary statement
Yes,
you
it is salary.
can give. Yes,
But then you said that he received in cash.
Earlier, my lord, because this aspect came perhaps after 2014. In the other case, we have seen from 2014 onwards, the salary was paid through bank transfer, my lord.
His retrenchment was in
2011. My lord, let me take instruction.
2011.
2011. Let me take instruction, my lord.
Procedural.
For a moment, I come to page 16. This is the order of the Honorable Justice Banerjee is remanded back, maybe relying on the
Letter.
letter.
Yes.
The second paragraph, Honorable
court has observed, I am not for a moment suggesting that the said letter conclusively establishes that the petitioner was in continuous service with the respondent corporation for 10 years. So this has to be analyzed by the trial court. And
Definitely.
let's not prove it by calling the person concerned or by calling any official communication. So therefore, the honorable court has rejected it. Please come. Heard submissions made on behalf of both the parties. So, the learned advocate appearing for the petitioner seeks time to produce document in support of the statement that the workman worked for 240 days in the year preceding his retrenchment and he received salary for the said period of 240 days prior 240 days in a year prior to his retrenchment.
My lord,
You state.
my lord, only one thing, my lord. In the interest of justice, because they are the authorities, let them also be directed, because if it is there, let them produce, my lord, because at that point of time, this receipt was not there, banking was not there. Let them produce fairly, let my learned friend comes here, and if my learned friend comes and says that not work 240 days, I have no case, my lord. You are saying will not do, na? Your authority has to, when he has worked, he has worked.
In the evidence, have you said that he did not work for 240 days?
No, no,
Which
no.
portion?
No, no, it is enclosed, page number 48. Nowhere they have stated, my lord. They have said the case is frivolous, this and that.
Or he has worked continuously
Yes.
as required for regularization of any workman under the Industrial Dispute Act.
That is with regard to regularization.
Page 2. Which portion did you read out? I read page 48, paragraph 1. Page 48, paragraph 1. I state that first party claim is not maintainable as he was never appointed by the second party, nor he had worked continuously as required for regularization of any workman under the Industrial Dispute Act. Then coming to page 2, I state that first party has managed to obtain certain documents which have no relevance with the incident case. I state that first party has worked on need basis with considerable gap and payment was made out of contingent fund and not from regular fund maintained to pay salary. Therefore, he cannot ask for reinstatement as he was never appointed under any order, nor his selection was made as per due process under the relevant rules. And that there is no sanction post available with the second party for the post of driver, as such the case of first party cannot be considered at all. I say that. Very well, I get it.
My lord, reinstatement and regularization are two different aspects.
10th or 11th? 11th.
11th, my lord.
Very well, list on 11th.
Twenty-six, WP and 992 of 2023.
Your Lordship, I am for the respondent, private respondent.
You appear for respondent.
I don't think, Your Lordship, anything is there now in this case because the building is totally demolished. They have left the
I am
premises.
not on the demolition portion, I am only on the.
It's already demolished, everything is finished. Now the only remedy is, if at all is available, is damages. What else they can seek?
Reinstated.
How can it be done through a court?
Whenever the construction has been carried out, I was a tenant, Your Lordship.
Your Lordship, whether this civil dispute can be decided here.
No, entered appearance seeks time to file affidavit in opposition. You are seeking extension. You are for the administration. You
I am
are
for the private respondent.
private respondent.
Yes. Landlord. I have already filed my opposition.
You've already filed your opposition. Very well. On the prayer of the learned advocate representing the administration. Time to file the affidavit in opposition is extended till the end of this month. Reply, if any, be filed prior to the next date of hearing. List in the next circuit.
Obliged.
Twenty-seven, WPA 1001 of 2023.
I'm for the respondent.
Now this week,
Not this.
on the prayer made on behalf of the learned advocate representing the petitioner, the matter stands adjourned for this week. Stop list on 10th, Tuesday. Please enter the appearance for the respondents. 27, 28, 29,
Till 31.
32.
30, 31.
32.
1 minute, till 31 is with analogous matter.
Yes.
Let order be recorded. 32, a fresh order has to be recorded. 32 is for the respondent. Very well, then same order will go.
Item number 33, WPA 1011 of 2023.
My lord, I am appearing on behalf of the writ petitioner, my lord.
Yes.
My lord, it's a matter, my lord, challenging a illegal demarcation committed by the authority, my lord. My lord, we have given an objection to the same, my lord, that remained undisposed of till today, my lord. Only direction to the authority to dispose of my objection, my lord.
Mr. Shivabalan. Yes.
Sir, we have filed a written objection in opposition.
No, petitioner prays for a direction for consideration of his objection only, nothing else.
My lord, my lord. My lord, otherwise, my lord, the writ court have no power to interfere into the demarcation process, whether it is correct or not. That will be decided by them. We shall come up with a fresh cause of action. But my objection has not been determined, my lord.
Where is your objection? Page 53.
My lord, my lord, my lord,
National Commission for Scheduled Tribes.
my lord. There was an interference.
Respondent name has been deleted, madam.
Then who is the authority to consider? Demarcation, how will the demarcation, the Scheduled Tribe Commission do demarcation? Possibly the Tehsildar will do, isn't it?
Yes, ma'am.
Who is appearing?
Lord.
For Tehsildar.
Where is the representation before the Tehsildar?
Not there.
Not there?
My lord,
Where is it? Which page?
my lord, P5, my lord, that is the report. And my lord,
Page.
the objection was 41, page number 41 to 43, my lord, PC. Page number 41 to 43, my lord. Secretary Revenue, Andaman and Nicobar Administration, objection was made before the Secretary of the Revenue, Andaman and Nicobar Administration.
Please come. The petitioner prays for consideration of the objection raised before the Secretary Revenue, Andaman and Nicobar Administration for consideration of his objection, of their objection against the demarcation in connection with the land survey number 1074/3/2.
My lord, report dated 19/9/2022.
Don't mention the survey number. Are you occupying that land?
My lord, I am occupying. Partially, I am occupying.
Shareholder, there are other tenants.
All right.
They are the shareholders, my lord. Without our consent,
What
the
did
part is demarcated and is been sold.
Praise for consideration of the objection. In respect of a land which is partially occupied by the petitioner, along with others. So,
My lord, the report dated is 19/9/2022, which is
Very-
mentioned in my prayer. In my prayer, my lord, it has been mentioned.
Very
Page
simple.
number 60.
Have you annexed it to the writ petition?
My lord, that has been annexed. My lord, P5, page number 38.
The said objection was filed in response to the report dated 19th September 2022 by
My lord.
Tehsildar, Port Blair. Stop paragraph without entering into the claim of the petitioner.
My
Petition.
lord.
The instant writ petition is disposed of by directing the Secretary Revenue, Mr. Shiv Balan, Secretary
Madam.
Revenue,
Representation is made to them.
right?
Yes,
Uh,
My lord.
to all the stakeholders.
Yes,
hearing.
yes. To consider and dispose of the objection filed by the petitioners in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties at the earliest, but positively within a period of 6 weeks from the date of communication of this order. Stop.
I'm so grateful, my lord.
Shall pass a reasoned order and communicate the same to the parties immediately thereafter. Writ petition disposed.
Obliged, my lord.
I'm so grateful, my lord. Deeply obliged.
Yes, next.
Number 34, WP 109/23. I am appearing for the respondent.
Is the petitioner there?
It's now is for the petition.
None appears on behalf of the petitioners at the time of call. What is to be done? Is it ready for hearing?
Yes.
List the matter on 11th.
Number 35.
Adjourned. Adjourned till 11th. Record on the prayer.
I am appearing for the respondent.
Enter your appearance, please.
33,
My lord, I am appearing for the petition.
Would you like to continue hearing?
As per the convenience of the court.
If you want, I can.
No,
No, it's all right. If you are ready, then it's okay.
I am ready, my lord. No
Yes,
issue.
then please give.
Or it may be taken up tomorrow at the first matter, anything as per the. He is out of service, my lord.
Are you ready?
I am ready, but if your lordship can take it up tomorrow also.
Very well, only not today.
My lord, my lord, let it be upgraded, my lord, so that this can be taken.
It'll be there in the list.
Yeah, updated.
Obviously, because the top matters are not there, so your matter will be there in the list.
My lord, I permitted to mention,
Yes.
item number 3, my lord, when matter was called, I was in court number 2, my lord.
What has happened?
My lord, it was adjourned to 11th.
You don't want adjournment?
No, I want to do it, my lord.
Do it. Do it. Who is your other side?
My lord, Mrs. Babita Das is there.
When the date was fixed
May fixed on Monday, my lord. I'll inform.
instead of 11th or 9th?
My lord,
Very well, 9th.
I'm deeply obliged.
Intimate Ms. Das.
Yes, definitely.